Sorry. Yes.
May please allow. Item number 38 of orders, my lord. This matters kindly password for the demand.
30,
38.
38. Why is it for orders? Why is it for orders?
Rule was issued, my lord.
So rule was issued, it should come for hearing.
For a fiction hearing.
38 to some. All right, we'll pass orders. Yes. It should come for hearing. Steps not taken. So affidavit not filed.
Affidavit not.
All right. Matter will be listed after 2 weeks, enabling the respondents to file their affidavits.
Maybe Your Lordship.
Yes.
I beg to mention item number 5 minutes. May be adjourned for the day.
Wait. 5 item will just come now.
I
Wait.
taken the consent.
Wait for your turn. Yes.
Item number 21, and for the respondent has been newly engaged, can be taken up after the week.
Have you taken consent of
Yes,
this?
I have taken consent.
Item 21 be listed after 2 weeks. As Mr. A. Ganguly, Learned Counsel, appearing for respondents 1 to 4, submits that he has been recently engaged and needs to complete his instructions. List accordingly.
May it please Your Lordship, my lord, with the consent of others, sir, I beg to mention item number 4 and 8. My lord, I could not prepare the bill due to my daughter's illness.
4 and 8.
I am praying for 2 weeks time, my lord. Any date after 2 weeks.
All right, 4 and 8 after 2 weeks.
Yes, my lord.
At the request of Learned Counsel for the petitioner. Yes.
Yeah, please.
My lord.
Item number 15.
15.
15, 1 thing.
Yes.
I am seeking time on behalf of D. Deca. The petitioners are intending to engage new counsel. So 2 weeks time may be given.
You are Mr.
I am D. Doctor. Appearing on
D.
behalf of
Doctor,
D. Deca.
appearing on behalf of Mr. D. Deca submits that you are no longer appearing in the matter.
No, we are appearing with the clients need a senior advocate along with us.
Submits that the senior counsel is being engaged and therefore the matter requires the matter be adjourned, enabling them to complete their instructions, list after 2 weeks.
All right.
May I please, Your Lordship? Lordship, I beg to mention for item number 31. Lordship, matter has become infructuous.
Your name, please.
U. Hazarika.
MSU Hazarika, Learned Counsel, appearing for the petitioner, submits on instructions that the writ petition has become infructuous. Accordingly, the writ petition stands dismissed as infructuous. Interim order, if any, stands vacated.
Obliged.
May it please the Lord. I beg to mention item number 40, Lordship. This matter is supposed to be withdrawn, Lordship. We need required some infraction, Lordship. Fix it on Monday, Lordship.
Item 40, in the request of Mr.
PP Fugon. PP Fugon, Lord.
PP Fugon, Learned Counsel for the petitioner.
Lordship.
Matter stands adjourned to, let it be on Wednesday,
Lordship.
13th.
Obliged.
May it please Your Lordship. I beg to mention item number 36, Your Lordship. This matter has become infructuous, Your Lordship.
It is submitted by MS Bhuya, Learned Counsel for the petitioner, that the directions contained in the order dated so-and-so, passed in WPC so-and-so, has been complied with, and therefore petitioner does not wish to press the contempt petition any further.
Obliged, Lordship.
The contempt petition accordingly stands closed. Yes.
This matter pertains to selection and appointment.
Selection and appointment for
In a great post in health and family welfare. We have order 1/12/2021.
Notice has not been issued here.
Notice has not issued, and my lord, the contention of the petitioner, because if your lordship peruses order dated 14/12/2021, which shows that my lord, the petitioner secured much lesser mark than the cutoff marks, my lord. And otherwise also, my lord, the petition is not maintainable because my lord, the selection select list was published on, my lord, 21/10/2019. Appointment has been made and petitioner has preferred this application after 2 years, my lord, on October 2021, my lord. Select list also otherwise they remain valid for a period of 1 year only, my lord.
But if within that particular period, the petitioner filed RTI application before the concerned authorities, Lord. But they delayed the process, Lord. And they did not provide the information.
No, what is your grievance here?
Grievance, Lordship, I have appeared in the examination
Hmm.
and the petitioner was confident that he will clear the examination. Lordship. And when the result was declared, he was not cleared by examination.
Your lordship may peruse order dated 14/12/2021, my lord. Because the cutoff marks was 76 and petitioner secured only 53 marks, my lord.
Lordship, there is 1/12/21. You may kindly order is at 1/12/21. In that order, the
There were
appointment-
certain marks directed to be obtained
Yes,
Yes, my lord.
in respect of roll numbers.
Yes, my lord.
Have you got it?
My lord, on last occasion, my lord, I produced it, my lord, but somehow, my lord, since notice has not been issued and our file has also been misplaced. I am using this file because that time notice was not issued. No extra copies were served to me, my
You
lord.
produce it by 13 next, but after 1 week, you produce
my
it
lord.
after 1 week.
Yes, my lord. And otherwise also, my lord, if the persons, the petitioner alleging that the roll number mentioned in his petition, they have obtained lesser marks than him, my lord, he has to make them parties, my lord.
Provided the marks are lesser.
Yes, my lord.
In order to do that, you have to produce the marks.
Yes, my lord.
So you produce the mark
Yes, my lord.
list after 1 week. Hard learned counsels for the parties. List after 1 week, enabling Mr. DP Pora, understanding counsel, to produce the marks obtained by the roll numbers. You get the roll numbers here in this order 1/12/2021 by the roll numbers so and so so and so. Stop. This direction was earlier issued by this court by order dated 1/12/2021. Stop. Mr. Bora submits that he will produce the marks by the next date fixed. Give a date after 1 week. 1 week,
10 days, my lord.
right after 10 days.
20. 20.
Make it 21st. 21st.
20. My lord, he may be asked to serve a extra copy, my
You
lord.
furnish an extra copy
yes,
by today. By today.
yes.
Yes.
God bless you.
None appears. Huh? I call again after some time. Yes, Mr. Biswas.
Matter relates to the appointment on compulsory ground. But what happened? His father was working in the Regional Institute of Mental Health at Pur. He died in 2010. Thereafter, my lord, he has applied for the compulsory appointment, but they have given him to serve under a contractor. At least 50 Group D workers have been engaged by under a contractor. They are paying the entire amount to contractor, and contractor is giving lump sum amount. That is our grievance, but we are not getting any scale.
This is a independent body, or is it an?
Hey, but initially it was Gov to Assam, then under NEC, then it is taken by Gov to India, Minister of Health. Now entire finance comes Gov to India, Minister of Health. Earlier it was funded by the NEC. My lord, there was a memorandum of understanding with the NEC when institute was taken up. If they produce, my lord, there is a condition that they will absorb all the employees. And they have absorbed. Now they are saying, my father came from Assam government originally. So how my widow mother is getting pension, all these things. My lord.
Who's for the, Mr. Bora,
There they have got
Health
a
Department.
advocate.
This is relating to Tejpur Mental, Tejpur
Mental health.
My lord, that is not
Regional Institute.
that is
council is there.
that is under the
So if he's not there, we'll enlist the services of.
No, they have got their lawyer.
But the lawyer is not available.
Yes.
What can be done?
Chaudhary is there, Chaudhary.
Who's the council?
AK also.
No, this is interested Chaudhary.
You find out, we'll call it after some time. If he's available, we'll find out. Meanwhile, Mr. Bora, you can get the instructions. What is the status here?
My lord, that is not our state government institution, my lord. That is under the central government, my lord.
Hmm.
Central government Atomic and Research Department.
Then Mr. Roy can get it. Obtain your instructions here. Standing council is not available.
I will inform the standing council lordship.
No, standing council is not available. You inform the department that we are asking for their state.
Lordship,
I'll give you address.
What is the status here?
That I can.
If-
Mr. Biswas will furnish an extra copy.
Lordship.
Mr. S, heard Mr. S. Biswas, SC Biswas, learned counsel for the petitioner. The writ petition pertains to a claim of the petitioner seeking compassionate appointment under the Lokopriya Gopinath Borderline Regional Institute of Mental Health, Tejpur.
Atomic and Research Department.
Stop. The father of the petitioner died in harness as he was working as
A good deed.
a Group D employee under the same institute. He died in harness on 12/7/2010. Stop. The claim of the petitioner has not been considered by the authorities concerned and therefore he has filed the writ petition. Stop. Notice in the matter has been issued by this court as per Becker's 9/10/2015. Stop. The court is informed that the institute has a standing counsel. However, the learned counsel, standing counsel is not available in court today. The court therefore requests the assistance of Mr. S.S. Roy, learned CGC, to communicate a copy of this order to the institute and furnish necessary instructions to the learned counsel to be placed before the court by the next date fixed. Stop. Let the matter be listed again on 21st, 21/9, by which date the learned CGC will endeavor to produce the necessary, furnish the necessary instructions in response to the claims made by the petitioner. Stop. A copy of this order be marked to the office of Mr. S.S. Roy, CGC, for communication to the LGBRIMH,
Lordship.
Tejpur. List on 21st.
Lordship. Obliged.
You will furnish him an extra copy.
Telephone number again.
Yes, 5.
Yes, my lord. I mentioned in my lord. I'm for the respondents, my lord. On behalf of Y. Dole, my lord.
You are for the respondents.
Yes, my lord.
Which respondent?
1 and 2, my lord.
Who's
So,
for
my
the
lord, parties to
petitioner?
the dismissal from service.
Who is for the petitioner? There are only 2 respondents, Union of India and Commandant.
Yes, my lord. 1 and 2.
1 and 2. So what are your instructions?
Let me adjourn, my lord. We have already filed our affidavit, my lord. Actually, petitioner will file reply.
Petitioner has already filed reply. He filed reply.
No, sir. No, my lord.
None appears for the petitioner on call. Mr.
SZ Rahman. SZ Rahman, appearing. on
S. Z.
behalf- Why
Roman, appearing on behalf of
Why the lord?
Mr. Y. Duloy, submits that the affidavit on behalf of the respondents have already been filed. Accordingly, list the matter for admission after 2 weeks.
My lord.
Make this so.
None
Lordship, here in
appears.
this case, Lordship, although as has been stated, Lordship, his mother is a teacher, died in harness. Also, at the same time, his father also was having a government job, Lordship, and his father retired, and after retirement, the death occurred. So, and basically, Lordship, the parties hearing made, Lordship, are the police department, Lordship. And we have,
Some affidavit was required to be filed.
so we'll file the affidavit, Lordship. Everything is ready, Lordship. We'll file the affidavit.
That was what was stated 1 year back. Where it has not been filed.
We'll file the affidavit.
None appears for the petitioner on call. Mr. CKX Borwa appears for the respondents. Who submits that the affidavit is ready and will be filed within
1 week, Lordship.
1 week. Let the matter be listed again after 2 weeks.
May I please your lordship? The petitioners are all physically disabled persons, my lord. What happened in this case?
Lordship, before my learned will start, Lordship, here in this case, Lordship, this issue belongs to the Department of Social Justice and Empowerment, Lordship. In that department, Lordship, a standing counsel is there, Lordship. R.L. Das is there, Lordship. His name is not reflected here,
It's not a ground for adjournment over 2018 matter.
Lordship.
Then you inform him, we are here. You inform him, we'll take it up after a while.
Lordship.
Yes, Mr. Rock.
My lord, in this case, my lord, I have not yet received any instruction, my lord. Recent instruction, I don't have, my lord. I have
We are closing it.
closing.
We close it. What is the point? 2018 matter.
My lord, and selection process, my lord. Better, my lord, I may be allowed to do, my lord.
You want to withdraw, all right. Mr. S. Hawk, learned counsel for the petitioner submits on instructions that he'd like to withdraw the writ petition. Mr. C.K.S. Borwa appears for stay. Accordingly, writ petition dismissed on withdrawal.
Have a liberty may be granted, my lord.
What
If-
liberty?
My lord, if anything arises, my lord.
If
Only-
anything arises, then you, in new cause of action, you don't need liberty.
Even then, my lord,
With liberty.
my lord. Oblige.
May it please your lordship. My lord, I am appearing on behalf of Mr. S.P. Das. My lord, main counsel is actually not feeling well today. My lord, may kindly adjourn him.
Yes, any affidavits?
Lordship, one affidavit has been filed on behalf of PW Department, Lordship.
All right. Mister, your name?
Anshuman.
Mr. So-and-so learned counsel for the petitioner. submits on instructions that they are giving counsel is indisposed. Therefore, 6. An adjournment today. List after 1 week. Mr. CKS Borwai appears for the state. Yes.
Here I am for the respondent, my lord.
What is the matter?
What is regarding appointment of a cook, my lord? Cook? Yes,
In
in military hospital, my lord, CO 99 APO, my lord. Well, I was already appointed, I have joined, my lord.
you are for the private respondent.
Yes.
None appears for the petitioner on call. This writ petition was earlier dismissed for non-prosecution. However, by order dated 17/7/2019, it was restored. Purely for the ends of justice, matter stands adjourned for 1 week. Mr. Spencer appears for the private respondent,
Yes, my lord, respondent of 5.
respondent number 5.
May it pleases your lordship, lordship, kindly take up the matter after some time, lordship.
After some time,
Oblate.
Kindly pass over for the timing, my lord, may be taken up with 2 minutes.
why?
The senior, my senior is like.
Not 2, time being, not 2. Not at 2, time being. As and when your senior is available, please call him. None appears for the petitioner on call. On 28/8/2023, none had appeared for the petitioner on call. Purely for the ends of justice, matter stands adjourned for 1 week. For the day, list after a week. Mr. J.K. Goswami appears for the state. None appears. Adjourned, passed over for the day.
Well, in this case, the petitioner was a constable of my lord Srimas Shabal Lordship. My lord on my lord 16, my lord 2017, my lord, he was on sentry duty, my lord, at my lord 11, my lord PM Lordship. My lord, at that moment there was my lord hiring from outside by the miscreants, my lord. My lord, he was my lord discharging duty, my lord. Others were my lord at rest, Lordship. My lord, at that moment, my lord, he retaliated, my lord. For that, my lord, these miscreants, my lord, played a way, Lordship. He my hired, Lordship. one of the, my lord, hiring from other side, lordship, my lord, was, my lord, hit his left hand, lordship. Now, immediately he was, my lord, given first aid, lordship, then thereafter on 17, my lord, 10, 2017, my lord, he was admitted in, my lord, or some, my lord, medical at Bongaigaon, lordship. The blood sample, my lord, was also examined, my lord. Many tests were done, lordship. During blood examination, my lord, alcohol examination, it was found negative, lordship. Now thereafter, my lord, summary force court was held, lordship. That is, my lord, kindly see, my lord, at page 66. Page 66, my lord. The sentence was passed, my lord, dismissed for dismissal from service, lordship. My lord, during the proceeding, the, my lord, medical documents were not, my lord, brought on record. Those were suppressed by the, my lord, commandant, my lord, summary force court, lordship. My lord, the charge say on the charge saying that the lordship, I was, my lord, intoxicated, my lord, and hired myself, lordship. And this was the charge, my lord, many 4 charges, my lord, related to this, lordship. And I was dismissed from service, lordship. Kindly see, lordship, the document, lordship. The medical test, my lord, that was done by the doctor, my lord, when he was admitted by the departmental officer, lordship. Kindly see at page 20.
Yes.
My lord, page 20 is the, my lord, annexer B, my lord, alcoholic report, lordship, negative, my lord. My lord, main charge was that, lordship, by intoxicating himself.
When did the incident occur?
My lord, on 16, my lord, 16/10/2017, lordship. My lord, on 17, my lord, itself, he was admitted in the hospital, lordship, my lord, by the departmental officer, lordship.
For?
My lord, treatment, lordship.
For what treatment?
My lord, a bullet injury was on his hand, lordship. My lord, he was also injured, lordship. Then, my lord, he was medically examined, and this is the examination report. This document was, my lord, suppressed by the, my lord, departmental authority, the commandant, lordship.
No, he was admitted where?
At, my lord, Bongaigaon, my lord, nursing home, and Lower Assam, my lord.
They do not have a pathological unit.
My lord, it is there, lordship. This is the Lower Assam.
This is by a private lab.
My lord, private hospital, my lord, in that hospital, the, my lord, commandant admitted him, lordship. I did not admit myself, lordship. And that document, my lord, was suppressed by the commandant, lordship. And this entire case is based on his intoxication, lordship. If the intoxication is, my lord, negative, my lord, how the, my lord, charge is brought, lordship? All the charge should be, my lord, should have been negated, lordship.
Where is the summary court order? Summary, there was some summary trial, summary court held.
Yes, lordship.
Where is that order?
My lord, summary court is, my lord, only, my lord.
Where is your discharge order?
Discharge order, my lord, sentence is there, discharge order, no. The discharge order is not, that is not available, lordship.
Then? Mr. Dev Chaudhary, you are appearing in the matter.
My lord, affidavit has not been filed, my lord, it's not.
It has been filed. One affidavit is here.
Perhaps this case is allotted to somebody else, not with me, lordship. Not at the record.
Affidavit is here.
My lord, copy is not with me.
A copy you will have to collect. How can an affidavit be filed without serving you copies?
But copy is not. If it is provided, not with me, lordship. Actually, in this case, my lord, Mr. Borua's advocate, my lord, because pending over his, my lord, ailment, lordship, I was, my lord, given back, lordship. Then I was engaged, lordship. Whether it is
All right, for
provided or not.
admission hearing.
Yes, lordship.
List for admission hearing. Affidavit is filed.
My lord, I may be allowed to take a copy from me.
You take copy, you take certified copies, who's stopping you?
Lordship, I will arrange.
For admission hearing, give it. Heard learned counsels for the parties. Matter will be listed for admission hearing,
28th of my lord, this month.
September.
Lordship. How like that?
We'll be filing the affidavit today, Lordship. During the course of the day. Lordship, the matter may come up next week, like along with the affidavit. Lordship.
In that
We are
case,
given 1 week time to file it.
Lordship, today it has come after vetting, Lordship.
Yes, madam.
Lordship, then in that case, we'll take another 1 week to file the rejoinder.
MSR Bora, Learned Standing Council Agriculture,
Lordship.
submits that the affidavit in opposition has been received and it will be filed today.
Today, Lordship.
We'll record it.
Yes, yes, Lordship.
It will be filed during the course of the day. MSB Chaudhary, Learned Counsel for the petitioner submits and the matter be listed after 2 weeks, enabling the petitioner to file any rejoinder if required.
Yeah, I pray for a date, Lordship.
List after 2 weeks, give a date after 2 weeks.
Oblige.
Oblige, Lordship.
Oblige, Lordship.
কি করো জানি মতো তুমি থাকতো না কি ভুল মন এখানে করে
May I please? One of the petition before my lord, we are working with the Guwahati Jal Board from 2015 on contractual basis. And their services were being continued from time to time. And my lord, it was that they will continue till regular employees are appointed. In 2018, government sanctions around 84 posts for that organization. And they were supposed to go for regular recruitment, but what they did, my lord, they again went for a contractual basis appointment advertisement. We challenged that before this honorable court. This honorable court protected our interest that ad hoc should not be replaced by another ad hoc, and we should not be replaced without, my lord, the leave of this honorable court. That was the order passed, my lord. They have also filed an affidavit wherein also, my lord, they have not denied the fact that they have not gone for a fresh contractual appointment. Only the names of the posts were, my lord, tweaked a bit. Officers, UDA, office assistant was made UDA and LDA to that extent, but the works were same. But today, my lord, I'm also not under, if my friend can have some instruction whether in the meantime something has happened, my lord.
Right, my lord. I mean, sometimes I don't have the instruction whether after the advertisement dated 12/12/2018, whether it has proceeded or not.
Because it may not have proceeded because they have to take a leave from this court. There was no leave granted.
We'll fix it after 2 weeks, but in the meantime, we'll get the entire instruction.
There any interim order?
There is an interim order, but it should not be 4/1/18.
4/1/19. 18.
Not be. Mr. S. Bora, Learned Standing Council, appearing for the respondents, all the respondents. You're appearing for all the respondents?
My lord, I am
Here
here
for
for 3.
respondent number 3, madam.
For respondent number 3.
2 and 3. Lord.
2 and 3.
All, my lord. All.
Only.
For all the respondents, submits that you'd like to obtain instructions with regard to the status of
One of the petitioners and the advertisement.
status of the
Service of the petition.
services of the petitioners as well as vis-a-vis
Vis-a-vis.
the advertisement which was issued for
My lord, 12/12/2018.
page number.
Page number 77.
12/12/2018 for filling up the post of they're working as what?
My lord, we were working under different posts.
For filling up various posts,
Various
including the posts in which the petitioners were are also working. Let the matter be listed after 2 weeks as prayed for. Mr. UK Nair, Senior Counsel, assisted by MS
D. Mohanto.
D. Monroe, appears for the petitioner. List after 2 weeks.
Much.
Yes.
Also for time being manner.
Why again?
Senior into the way manner for time being manner.
Yes.
Lordship, we need some further time to file the affidavit. We have not received it.
You have been given time 4 weeks earlier.
Yes.
You have not received your instructions.
No, Your Lordship.
We'll give them further 2 weeks time to file their affidavit. Mr.
I bought her.
I, Botakur, learned counsel appearing for the petition respondents. He is permitted 2 weeks further time to complete their instructions and file necessary affidavit if so advised. Mr. VK Borwa appears for the petitioner, does not object to the prayer made list after 2 weeks.
Hello.
Yes.
Lordship, I have challenged the impugned award of the labor code. The brief fact of the case is that I was appointed as a sub-editor in a Bengali daily newspaper, which is called Dainik Jugasankar. As a sub-editor, my responsibility was to elaborate and shorten the news item. But in the year of 2016, the management of the Dainik Jugasankar have transferred me at Tinsukia, not as a sub-editor, but as a correspondent. So accordingly, I have challenged the transfer order before the Assistant Labor Commissioner on the ground that such order is illegal because it changes the nature of the job.
Where is that order?
Transfer order is on page number 15. May I have your permission, Lordship, to read the transfer order?
Yes.
Subject transfer. In view of the decision of the management to improve the content of Dibdibur edition of Dainik Jugasankar, it is felt necessary to have good reporting hand in Tinsukia. The headquarter of Tinsukia district under the Dibdibur edition circulation area. In the interest of the edition and company, you are hereby transferred to Tinsukia and you are advised to start reporting from Tinsukia from 24th October 2016. The order itself is very tangible and clear that the management transferred me at Tinsukia to start reporting, that is to report. Whereas my designation is a sub-editor.
Where is your appointment order?
No, that is the fact, Lordship. It is the newspaper industry of Assam, except the Assam Tribune. No one issues appointment letter. They orally appoint and they maintain some registry.
Who's for the newspaper?
Newspaper is
Not a party.
Yes, they are party, but they are not representing. The Justice Service, they have Justice Service also availed, and the order passed by the Honorable Court was communicated to them by way of Dusty, but they.
What was the order passed by the tribunal?
Labor Court, Lords.
Labor Court.
It is on the page number 32. Lordship will find the relevant portion, the page number 33.
Yes.
Lordship, I'm reading the second paragraph. The admitted fact as per pleading in argument is that workman was permanent employee of Dainik Jugasankar under the management of Dainik Jugasankar, but the management arbitrarily and illegally
transferred him by letter number so and so to Tinsukia district as correspondent, and he challenges the transfer order on the ground that sub-editor cannot be transferred as correspondent, did not pay any heed to his request. Then he lodged a complaint before the Assistant Labor Commissioner. In cross-examination, Asimul Sadat Osmani asserts that he did not submitted the appointment letter before the court. Even he did not file any document that he was assigned to work in Guwahati. However, the exhibit photocopy of the transfer copy marked as Exhibit 1. The Asimul Sadat Osmani took plea that on being requested, he was granted leave. However, after the leave period, he was not allowed to join in Guwahati Dex as sub-editor, and the management instructed him if he desired to continue his job, he should join as the correspondent in Tinsukia district. Thus, it is an admitted fact that management transferred Asimul Sadat Osmani by order dated 15/10/2016 was in the interest of the newspaper and to improve the Dainik Jigasankar. There was no change in the nature of job since he was transferred as sub-editor. Also, this line is important. That the finding of the learned labor court is that I was transferred as a sub-editor. Learned counsel for the management would submit that the case of transfer Asimul Sadat Osmani does not fall under the industrial dispute. The learned counsel for the management refers the decision reported in 1974 three Supreme Court cases 510 and submits that employer has right to transfer. But Asimul Sadat Osmani never claimed that he was victimized, nor the management took unfair labor practice by violating condition of service. The section 2 within bracket K of the Industrial Dispute Act means any dispute and employers or between the employers and workmen or between the workmen and the workmen which is connected with the employment or unemployment or in term of employment or with the condition of labor of any person. Thus, it is clear enough that transfer of Asimul Sadat Osmani to Tinsukia as sub-editor from Guwahati Dex by the management does not fall under the purview of the section 2K, and such transfer, in my view, does not affect directly or substantially in the interest of Asimul Sadat Osmani. The transfer is an identical to employment unless it is ill motive or punitive. But in case there is no allegation of any illegality in transfer of Asimul Sadat Osmani, the principle of no work, no pay is also important. Work without work claiming wages from the date of absence, that part is not important. So two findings, erroneous finding of the labor court is that first, I was not transferred as a correspondent, I was transferred as a sub-editor. But it is not clear from where, from which document the learned labor court came to the conclusion that I was transferred as a sub-editor, not as a correspondent. And second point is that with my reference case was dismissed, that my case was not covered under section 2K of the Industrial Dispute Act 1947. As per the section 2K, the transfer is not an industrial dispute. Lordship, I'm coming to the first point. The learned labor court, it's a reference case. They decided the reference case. The issue was framed. So the labor court cannot go beyond the issue and they cannot make any extra issue. They will have to decide the issue which is forwarded to the learned labor court by the competent authority, that is the Labor Welfare Department of the Government of Assam. Lordship, this reference is there in the page number 16.
Yes, anyone for the respondents? You appear for labor.
Lordship, I am appearing for the official respondents, Lordship.
We'll admit it, we'll call for the records.
Yes, Lordship. And in the meantime, Lordship, we will also file affidavit.
What affidavit? Records are there.
Records are
Unnecessary hard learned counsel for the parties admit.
And
Call for records in connection with what is the reference case number? Reference case number 10 of 2017 from the Labor Court, Guwahati. Matter will be listed for hearing after receipt of the records. LCR is called for.
Lordship, since it is a 2019 matter, in this,
We'll need the records.
and just my one simple prayer that if possible, contain the date may be fixed.
The records we call for first. Matter will be listed after 4 weeks, be listed after 4 weeks.
Obliged.
You right, matter be listed upon receipt of the LCR or after 4 weeks, whichever is earlier.
Right, please, Lord. Main grievance of the petitioner before your lordship. As your lordship aware of, there is Ayush Ministry of Health and Family Welfare, Government of India. So my lord, Ayush include Ayurvedic, Yoga, Unani and homeopathy. Now what happened, my lord? In other states, namely the state of Tripura, Meghalaya, West Bengal, they given equal treatment to homeopathy doctor who have passed out from homeopathy college. But in Assam, my lord, every time advertisement is given, though Ayush includes these 3 disciplines, 4 disciplines, my lord, only Ayurvedic doctors are appointed. So, my lord, here, what I have referred, my lord, I have showing before your lordship from the advertisement, my.
No, what happened in the WPC?
My lord, that WBC, my lord, only thing is, we have said that WBC is pending before your lordship.
Still pending.
But that WBC is pending.
How? Which WPC you are referring to?
My lord, that WBC is pending.
What is the number of that WPC?
My lord, I am giving.
426.
Four 26 of 13.
So that has been disposed of, page number 80. Why do you say it is pending? It was disposed of on 24/5.
I'm coming.
Mr. Sheikh, you're not prepared.
Hello. That is not disposed of, my lord. The case is pending.
It is clearly written here, the writ petition is allowed.
My lord, I am to check the copy, my lord, in that case.
Matter will be listed after 1 week. That's the learned counsel. The petitioner is not complete with his instructions.
Obliged.
Mr. Upamanyu appears for the health department.
Respondent number 1.
Respondent 1, Mr. Medip or
Respondent 4.
respondent 4.
I need some accommodation today, my lord. We'll pick it on 14th, my lord.
What is the matter?
Matter is under department procedure.
You're on interim order.
Lord. On 14th, my lord.
14, I don't know. Then 15, we can have it on 15th.
Lordship.
A joint request list again on 15th. Or at the request made by Mr. S. Bora, not objected to by Mr. R.K. Dev Chaudhary. Matter be listed on 15th.
Okay.
As per order 38, your lordship, order to produce the records regarding communication about the reference of the matter to the DRB. As per order of this honorable court.
Yes. Which are the relevant documents there?
My lord, after my lord, these letters, my lord, how this it was communicated to my lord,
Your DIG law has opined that there is nothing wrong in the order, it needs to be
yes,
complied
my
with.
lord, yes, my lord. Thereafter, my lord, the directive, my lord, referred to the DRB, my lord.
Then
My lord, the recommendation of the DRB also, dear my lord, I have written the DRB flag like that.
but in rehabilitation, any strenuous work is there.
My lord.
Rehabilitation is for the purpose of not to put him to strenuous
My lord,
services.
even PT period also, PT also, my lord, PT period also, he is not unable, my lord.
No, what rehabilitation do you provide?
My lord, these all, my lord, those who are, my lord, in the rehabilitation, my lord, they must be in PT also, my lord, but even the petitioner, he is not able, as per medical report, my lord, PT also, my lord.
But the same does not reflect, my lord, the opinion of the DRB, my lord.
It is there, my lord.
DRB, my lord,
It is-
he is not for PT, my lord, it is not there, my lord.
Hmm?
The DRB opinion is not my submission.
It is here. This opinion is a part of the pleadings.
My lord, it is not part of the pleadings, my lord, but my lord, they challenge the order, the last order, rejection order, my lord.
You bring it on record.
Yes, my lord.
You bring this
Yes.
on record for him to.
Yes,
The DRB says you are not able to take part in any strenuous work, including physical and PT.
and DRP also not party respondent in this case, my lord.
Not necessarily.
Yes,
My lord, the earlier order of this honorable court, my lord, your lordship has.
Let him bring it on record. Do you have a copy of this DRB opinion? Do you have access to this?
I have annexed, my lord, in my impugned order, my lord.
that is not DRP.
Impugned order, my lord.
Page number
Page number 90, my lord.
90.
Yes, my lord. Paragraph 13, my lord.
That is not recommendation of DRP, my lord. My lord, there's only one, my lord, paragraph was, my lord, reflected, my lord.
Opinion of the DRB, there was paragraph 13,
Yes.
page number 90.
No, opinion is, this is just an extract. This is just an extract. This is necessary.
I'll file it.
So that you can go through.
Yes, my lord.
Their contention is that even for rehabilitation, you'll have to take part in PT, etc. and all these things. You can't do it. So therefore, no rehabilitation.
My lord, my lord,
It
standing-
is for you to say that for rehabilitation, for rehabilitated personnel,
Yes.
the regular rigors of PT, etc. are not required.
My lord, may I submit one thing, my lord? The standing order, my lord, page number, page number, my lord, 49. 49 for a moment, my lord. Standing order, based on which the earlier order was passed, my lord, 49. And relevant part, your lordship, will find page number 51, paragraph 6.
Yes.
Paragraph 6, my lord. This board will subject the person concerned to critical examination with a view to determine his physical and mental capability, aptitude, job requirement, etc. And addressing capability and health conditions, the person will recommend specifically that whether he or she can be rehabilitated within the force by assigning jobs mentioned in para 7 and 8, or my lord, there is a or provision, my lord. If the DRB is found him not my lord fit, there or the person is not fit for any kind of duty, specific reason of medical opinion, therefore recommended to be invalidated out. After critical examination of the person and assessment of his suitability for job, DRB will recommend any of the tasks for him as per specified below. So, my lord, there are also, my lord, if he is invalidated, there is my lord, paragraph page number
Before that,
52,
my lord, the
52, my lord,
page
is
50,
there.
my lord, paragraph 3, my lord, before that, my lord. Page 50, paragraph 3, my lord.
There is provision, my lord, in the standing order, my lord, if the DRB found him not fit, my lord.
No, where in the standing order does it say, or is there any standing order or notification to the effect that if you are to be considered as a rehabilitated person or a personnel,
yes,
you are not required to undergo the regular rigors of training, etc.
Yes, that is, my lord, not in the standing order. My case is based on the standing order, my lord. Standing order, my lord, as
You
per
have not
paragraph-
followed the question of the
Yes,
court. You get it on affidavit.
And paragraph 3, my lord, is page 50 is
No, let
clear.
you get this on
Yes, sir.
affidavit
Yes,
first.
sir.
Mr. S.K. Medi, learned CGC, has produced the records which contains the opinion of the, what is that DRB for?
Well, Departmental Rehabilitation Board.
Departmental Rehabilitation Board. The said opinion is not a part of the pleadings, and therefore he is permitted to bring the same on record by way of an additional affidavit. And copy thereof be served on the counsel for the petitioner. Mr. Kadir, learned counsel for the petitioner, submits that the matter be listed after
my lord, on 20th, my lord,
2020.
20, my lord,
20.
22nd.
oblige me.
22nd?
Of this month, my lord.
Yes.
Well, I'll be in Aizel bench, my lord, some other case, my lord. So matter will come on, but they, my lord, month of October, my lord.
My lord,
No,
he
not
submitted in
October.
the year 15.
You
my
file
lord.
it, you file it. You file it immediately.
Then, my lord, 2015, 25th.
25th, all right. Just on 25th. You can read it.
File.
Please, Lordship, pass over the matter for time being. My lord, I have a small player, my lord. Counsel Mr. B. Gogo is indisposed today, my lord. The matter may be listed in the next week, subject to lordship's convenience, my lord.
It is submitted that Mr. B. Gogoy, learned standing counsel taxation. Spoke. Paid it, they know that we have to have that. It's stopped. 15.
Highly obliged.
Wait, please, your lordship. Lordship, my senior is on legs. Kindly fix the matter at 2 p.m.
Not 2 p.m. After some, immediately after his speak. We'll keep it aside.
Obliged.
Mr. Kumar, we'll just take it up after the council is available.
But here issue is very small, my lord. But since matter is pending and the persons are going to be retired very soon, my lord, already 2 persons have been retired. The promotion matter, my lord. Since there is as per the 1963 rules, my lord, the person has to be promoted from UDA to superintendent, my lord, having 5 years experience, my lord. Only higher secondary was required, my lord, at the time. In 2019, my lord, the rule has come out, my lord, saying that instead of higher secondary, it has to be BA. Now, persons who are going to be retired, my lord, they cannot complete the PA. And otherwise, my lord, there is a provision also in the new rules also, saying that in some circumstances.
The vacancies that you are claiming to be promoted to,
My lord, since vacancy were there, my lord, but ultimately the persons who were the graduate, my lord, they have been filled up. By them, it has been filled up. Now, these persons who are only the half century and they have been remained, my lord. And now this person.
is there a law to say that the government cannot enhance the qualifications?
My lord, since there is the provision has been laid down, my lord, to relaxation of the qualification, my lord. That provision is there, my lord.
Have you applied for that?
Yes, my lord, we have applied, and initially I have come before lordship, my lord. Then matter was immediately disposed of, stating that whatever the representation was there, that has to be disposed of. And subsequently, they have disposed of, without saying anything, my lord, they have disposed of the matter, where they did not consider about the rules, my lord, what rule has provided, my lord. The rule is very specific, my lord. The rule, just time.
Have you
Reading the rules,
extracted
my
the
lord.
rule? Are the rules here in your pleadings?
Yes, already I have stated in my petition itself, my lord. The rule also I supplied, my lord. Probably it may be in the file itself, my lord. Lordship may have done this. Rule 16 is there, relaxation.
Where is the new rule of
New rule
situation?
2019, my lord. The
So which rule? Rule number?
rule 16, my lord,
Rule
is
6,
the relaxation, my lord, and the rule 5 is the disqualification, my lord.
Rule 5. Yes. What is the process for selection?
My lord, this
Criteria?
it is given itself, my lord.
Rule number, procedure. Okay.
7.
Yes.
And my lord, since in the similar circumstances, my lord, this honorable court passes some orders, my lord, considering that aspect, my lord, in the same footing, my lord. So, my lord, here the petitioners, they are working since long, my lord. Now, abruptly, these new rules has come in the field, my lord. And by dint of that rule, my lord, now we have been deprived. This is the problem now we are facing. And now this most of the petitions are going to be returned. Some are going to be returned in December 2023, and some are in February, like this matter. So only my prayer will be before Lordship that since the Rule 16 is there, my lord, to consider the grievances of the petitioners by relaxing the qualification, since they work for 25 years, 30 years, 35 years, like this, my lord. And where they will go now, my lord? And in the similar circumstances, this honorable court passed an order, judgment order, where the rule was provided that he has to be the B.Ed degree. And court says then no, since the person worked for a long time, and because of not having the B.Ed degree, he has been deprived for promotion. That in earlier occasion, the government rejected his prayer. This honorable court considered the prayer, and it was directed the government to reconsider the case of the petitioner, since it is the under the consideration of the government, my lord. So it was directed to the government to reconsider the case of the petitioner. That judgment I have, my lord, before this, which this honorable court passed on. And other judgment also relied on. I would rely on. But since the persons, these persons, they were working, they went for the basic training, my lord, and whatever the conditions were imposed, that they have already passed. And now when the promotion has to be given to the petitioners, now abruptly one rule has come out, and by dint of that rule, I have been deprived.
Your applications for relaxation was rejected.
One application, that earlier application was done, that was rejected. But second, another application, considering all these provisions of rule, that application was subsequently submitted. It is lying as in today, my lord. That Lordship will find that has not been disposed of.
Now, what is the stand of the government?
Now, the stand of the government is, my lord, only they are relying the rules that are saying that since the rule has come now, only graduate will be required. That's all. That is there, my lord. I have said, because of the rules, new rule, my lord, that new rule, rule 5.5, it hasn't provided graduation. And had there not been the graduation, certainly I would have been considered. Now, where shall I go, my lord, since I'm going to be retired? And now they are saying that, yes, of course, for the newcomer, the BA will be required or graduate will be required. That is different thing. But the person working for several years, 30 years, 27 years, 32 years, my lord, now they are at the path of retirement, my lord.
You have not challenged the rules as such.
My lord, since my lord, I have not challenged the rules, my lord, since the rule had there not been the provisions, my lord, I would have challenged, my lord. But since there is a provisions for relaxation, my lord, that is why I have come under the rules, my lord. This rule 16, my lord. So on the basis of the rules, the government may, Lordship may consider and direct the government to consider my case, my lord. Since in other cases also I have seen, my lord, regarding the age relaxation, all these things, my lord. They did not, the petitioners came before this honorable court. Single bench passed the order on the basis of the rules, my lord. I have some of the judgment, my lord, and if otherwise Lordship fix another date, my lord, I will rely all these documents, my lord, as part of my lord. Since
Mr. Nayak,
and the
what is there a provision for relaxation?
Yes, but lordship will see that rule seeking order. It pays 100. Now, earlier also they came before this court, lordship, and in terms of their prayer, lordship, in the writ petition, their cases for relaxation was considered by the authority and it was rejected. Lordship will find the rejection order at page 100. The lordship will see one thing. Lordship, this post superintendent is covered by another rule.
Is covered by?
Is covered by the rule of Secretariat service rules, lordship.
yeah, that I have.
That is 2019.
That's
They are till now, lordship, they are not part of that rule. They are covered by the Secretariat subordinate service rules of 1963. The first question will arise whether, even if he is not a member whose service is covered by this rule, lordship, can he claim relaxation of that service rule? That is one, lordship. He is not a member covered by that service rule.
So this Secretariat service rule starts from superintendent.
Yes.
And UDA
That is a promotional, no doubt that is a promotional post, but it starts from superintendent. And only this provision for relaxation can be claimed by only a member of service covered by that rule, lordship. That is the basic, lords.
No, from UDA to the superintendent. UDA must be.
Relaxation does not restrict it to be in respect of any member of the service.
No, lordship will see, who are the persons, lordship, whose services are regulated by this rule, lordship.
No, that's all right, but your source of service is promotion.
Yes.
Promotion not by, is it by direct recruit?
Yes.
Is there a provision for direct recruit?
No. It's for
only by promotion.
Yes.
So the promotion will have to be from a feeder category.
Yes.
Now, where is the restriction under Rule 16 to say?
Yes, that is my first submission, Lord. Lordship will definitely consider, as he has already prayed for time, lordship. Second issue will come, lordship, whether after amendment, lordship, this is the law settled by the Supreme Court, lordship, in at least 2-3 judgments are there, lordship. Whether a person claimed to be considered his promotion in terms of the law that has been amended, lordship.
No, that's quite right. But the question is that government is also, you must be a role, you must behave like a model employer. There must be some avenue, there are catena of judgments to show that a particular post, there must be avenues for promotion.
In my submission, that is not the position now, lordship. Why I am submitting, lordship, on the date when the rule was amended, they were not even eligible for promotion to the post of superintendent, even under the old rule. So no right of has accrued in their favor, even under the earlier rule.
No, we are not on that. We are trying to say, we are trying to understand that since your only source of recruitment is promotion, and promotion has to be from people belonging to the category of the petitioners, their only disqualification is that they don't have a degree.
Yes.
Now they say that they are at the fag end of their career. They are likely to retire. Now, promotion is not a matter of right, but to be considered for promotion can be crystallized to be of some right.
Lordship will consider that issue. Let my colleague make submission on that issue, lordship.
We want to know that
Why
if there is a
relaxation should be
provision for
given.
the government to consider their claims.
Yes, lordship, my submission would be, lordship, that this relaxation clause is a discretion of the authority, lordship.
That's right.
That is,
So that
they have
discretion,
decided.
if the government will apply the discretion, keeping the grievances of the petitioners, that we can close the matter. There is no problem on that.
Yeah.
But the discretion should not be, the prayer for relaxation should not be rejected on a technical ground. That
No, this
Sorry.
is not just technical, Lordship. Why their cases has not been considered, Lordship. That's speaking order is there, Lordship. But basic that is
No,
required.
their cases is that they do not provide, they do not have the degree.
Yes, there is lack of qualification.
Uh, This talks about rejecting the relaxation because each and every case we can't give a relaxation. Correct. But then the government must also come up with some avenue for these people who have no doubt put in long years of service, because seniority is also a criteria. Only because they do not fulfill the requirement of
Yes,
a
education
degree,
qualification. Yes.
they are out of the zone of consideration. Now, as you know, degrees,
Yes.
Are degrees, somebody will have to apply, sit for an exam, you'll have to be given permission, go and attend classes.
My submission will be in that case, they should have, earlier also, Lordship, many court has at least taken the view, Lordship, they should have challenged the rule, Lordship.
No, challenging the rule is one aspect. They may not have a grievance in respect of the challenge of the rules. We cannot spell it out for them or for you what the government should do. But if the relaxation clause is there, then as a model employer, the government should look into and find a way whether these people's grievances are actually genuine grievances to be taken care of.
But in this case, government rejected their.
I know government rejected, it is available before us, but that is only on the ground that we can't give relaxation to each and every.
That is one reason, Lordship. But Lordship will also consider the reason. Lordship, education qualification is the substantive requirement. Lordship. Whether that qualification can
We
be
are not on that.
relaxed or not.
We are not on that.
Lordship.
You have not changed the rule by making it merit come seniority. Your rules remain seniority with merit, which means the service rendered by a person has some role to play. Had it been merit come seniority or merit, then perhaps their claims would not have been justified. But seniority has a role to play. They score higher on the seniority part. You can't ignore that. For a person who's junior to them.
No, along with seniority, Lordship, that qualification, I mean, not just the graduation qualification.
No,
Lordship.
exactly. That's what I'm saying. Supposing there is a person, say one respondent, who has put in 15 years of service.
Lordship.
Or
In
10
spite
years
of them, Lordship. In spite
10
of
years
them,
of service,
Lordship.
but has a degree.
Lordship.
And the petitioners have put in, say, 15 years or 20 years of service, but no degree.
Yes, Lordship. But even before this amendment, Lordship, putting graduation as a requirement, Lordship, persons junior to him got promoted, Lordship, because they acquired the Group B training, Lordship. That was also in qualification. So seniority only will not.
So today, what is the position besides the degree part? Are they otherwise qualified according to you or not?
Lordship, so far as first petitioner is concerned, Lordship, if graduation is kept aside, Lordship, otherwise he is, except that qualification, he is qualified. But without graduation, Lordship, his case will
That's
not be.
That's what we are saying, because your criteria for promotion is not merit or not merit come seniority. It is seniority with merit. Means that seniority has a role to play. So the service which has been rendered cannot be totally ignored. Giving a go by to the fact.
Lordship will hear this matter. Let my colleague make submissions.
The whole purpose of trying to engage with both the councils is to see if the government would like to give a second look. That will.
Lordship, otherwise also this rule is already under silence. That issue is also there.
It's pending.
It's pending before the division bench.
But
that part is different, my lord. Since I'm not challenging because I'm not on this challenging part of the.
But that is not your argument anyway.
Yes, not. Only my.
This is not your argument.
Yes.
No, he's only for relaxation.
This is a
limited my argument. Only as
this is what fell from the court. This is not your argument, not your pleaded case.
Yeah. Only my case is, my lord, only under the rules 16, since the relaxation is there, my lord. So in other cases.
Can the court direct the government to give you relaxation?
Exactly.
Cannot.
My lord,
Can the court direct the government to give a relaxation?
no, lordship, in this case, my lord, this honorable court has passed an order, my lord, exactly in the same way, my lord. Lordship, I will look, my lord. Case 13, 14, and 15, my lord.
What is the fun in keeping court orders close to you? These should have been shared with councils and the court instead of you give us a list. If you are ready, if you have the judgments, you should request your colleagues to share it.
Lordship, that part, my lord. Lordship will fix the matter on Tuesday or Thursday, lordship. So that. মানুহ ৰিটায়াৰ হ'ব এতিয়া তোমালোকৰটো একো না মোৰহে দিগদাৰ হৈছে Para 13, 14, 15 lord. Are you doing that? 2021.
Yes. Mr. Nayak, you may like to go through these because more or less in the same lines that once a person is accrued some qualification, merely because there is a degree not in favor, will it be a ground to debar the person from being considered? There's no direction for promotion, but at least to be considered. Now they are out of the consideration because of the amendment in the rules.
Yes, for promotion, they have nothing. Lordship will take up this issue.
Lordship will take up the matter on Thursday, Lord, as partner matter. Because otherwise, again, matter will.
What partner matter? We are ready to complete the hearing today if you want.
Yes.
But you said you wanted some judgments to be placed.
That judgment is there, my lord, and on the basis of that judgment, lordship may pass the order.
We pass judgments on the basis of arguments made, Mr. Counsel. You have to make an argument. We'll have it on 19th. 19th? 19th.
Yes.
19th for admission hearing.
As partner matter. Otherwise, again, matter.
What is the magic about partner?
Since lordship heard the matter, my lord.
No, we have not heard the matter. We have not even gone through the pleadings properly. Because you have not urged the matter.
My lord, here the.
We'll take it up on 19th. We'll take it up on 19th. Let the matter be listed on 19th as prayed for by Mr. Chetri, Learned Counsel for the petitioner, Mr. P. Mr. Nayak appears for the respondent.
Yes.
Anyone else? Mr. Goswami for
1 and 3, Lord.
2 and 3.
Respondent 1 and 3.
1 and 3. Matter be listed for admission hearing on 19th.
Oh, further hearing.
On 19th.
Since my lord, now and that is there, my lord, since the persons are going to be retired, my lord. And
we'll take it up on 19th.
Again, my lord, Since
When are
lordship,
they retiring?
no, since lordship has.
When are they
taken-
retiring?
Since lordship has considered that aspect, my lord, and lordship has heard the matter, my lord.
When are they retiring?
Now December, my lord.
December.
December.
We will ensure that there is no difficulty in getting
No,
your
lordship-
instructions
Lordship,
before they retire.
lordship will make it a part of my lord, so that it will be, my
All
lord.
right, all right. We'll take it up on 19. Don't worry. Take it up on 19.
This matter pertains to the appointment on
Yes.
compassionate your lordship grounds. The petitioner was initially, he was recommended by the DNC. Subsequently, the minutes of the state level committee has rejected the case of the petitioner. Showing want of vacancy, your lordship. Between minus lordship, page 30 is the between minus and page 31 is the operating data.
They filed their affidavit.
Yes,
Lordship, they filed affidavit. by the
paragraph
secretary.
4, lordship. In my affidavit.
Yes.
Lordship, here it is as per the vacancy position submitted by the executive engineer Guwahati division irrigation Guwahati, one numbers of appointment of on compassionate ground had already been made in the cadre of Khalasi, which implies no further appointment on compassionate ground is possible against the cadre strength of 22. Therefore, the SLC considered the application of Minal Das and Sri Ratan Thakuria under para 14A 6 by plumbing peon chokidar helper and APPO post. Even after plumbing, only one extra post within the prescribed 5% quota would be found against total cadre strengths of 28 numbers. However, as the father of Sri Ratan Thakuria had expired on 24/10/2010, much before the date of the father of Minal Das 13/1/2013, Sri Ratan Thakuria was recommended by SLC for the single available post. Moreover, OM dated 9/9/1983 have already been suspended by the OM so-and-so 2015.
What has been suspended?
Lordship,
What was suspended?
OM, Lordship. New OM is coming, Lordship.
New OM.
Yes,
Ah.
2015 OM is coming. Therefore, earlier OM's Lordship was suspended.
But the application was filed during the earlier OM.
Lordship.
It was considered in DNC in the year 2017 and 2017. And so far the lordship may perish the page 26 of my petition, lordship. This is the statement of the post. Thank you, your lordship. That is the total cadastre that have shown as page 22. Lordship will find page 26, lordship. In the 7 column, your lordship, number of cadre already appointed on compassionate ground is that cadre 1. Number 8, your lordship, number of posts now available under 5% quota against cadre strength for appointment on compassionate ground is 1.1. The post is already available, your lordship. And the so far the projection of the respondent in para 4, it is in respect of the post of peon. And the cadre strength, lordship, total cadre strength of the grade 4 lordship will find page 28. Page 28 is the cadre strength of all the grade 4 posts. It is 50 posts.
So what is 5%?
Lordship, 3 post, 2.5. And the so far page 26 is concerned already one post already been soon has been vacant, your lordship. Under compulsory appointment.
What is their reply to this?
They have already in paragraph 4, they have already stated that the so far the person concerned recommended some Thakuria lordship, which
Yes.
is again in respect of peon post, your lordship.
Yes, yes, that's it.
And so far the statement of Halasi post against Kutal
This
Kedar
one post shown is for appointment of Mrinal Das.
lordship.
You are referring to column 7.
Lordship.
Yes.
What is the name of the petitioner?
Minalda.
Oh, okay. What is the person who was earlier appointed?
Thakuria.
No, by the same minutes, one person name recommended for the post of peon. That peon post not has taken into consideration in the this page 26 a lot. Only Khalasi post they have taken into consideration. And the so far the possible find minus of the meeting lordship page 30 in the last number 3 recommendation lord. Last recommendation, Ratan Thakuria, son of late Dhiren Thakuria. He was recommended by the district level committee in the year 2019. And as per clarification given by the respondent in para 4, this has been recommended for the post of peon, your lord. And that peon post not taken into consideration in page 26. And that is why I have enclosed the para page 28, all the cadre strength of the gate 4 post. It is which is come 50 post.
Yes. How many posts were considered by SLC?
SLC is total considered 28 total stank lordship. Out of that, one
From where do you say that?
is in my affidavit paragraph 4 lordship.
There are 4.
Paragraph 4. Therefore, the SLC considered the application of Sri Minal Das and Sri Ratan Thakuria under paragraphs 14A and 6 by clumbing peon, chokidar, helper, and APPO post. Even after clumbing, only one extra post within prescribed 5% quota could be found against total cadre strength of 28 numbers.
That's the is totally against the Annexa 28, your lord. Oh, sorry, page 28 of my deed petition.
Your statements are not clear. What exactly do you want to signify? Para 4. What does he want to say that under para 14A6, peon, chokidar, helper, APPO? What about Khalasi? Khalasi is not taken into account. Counsel for the petitioner is referring to page 28,
Lordship.
where it shows the cadre strength.
It's,
It includes Khalasi.
Khalasi is 22, Lordship.
That's right.
It was earlier considered, Lordship. It was considered in, Lordship, in first, I submitted in the first part of my affidavit in 4, Lordship, paragraph 4, Lordship. It is stated that as per the vacancy position submitted by the Executive Engineer, Guwahati Division, Irrigation, Guwahati, 1 numbers of appointment on the compassionate ground had already been made in the cadre of Khalasi, which implies no further appointment on compassionate ground in the possible against a cadre strength of 22. It means 22 had already been considered, Lordship. It is reflected in page 28, Annexa 8 of the writ petition, Lordship. It is 20 out of 22, Lordship. It is
one post.
Yes, 1 post, Lordship. It is strength on cadre strength. It means column 2 of Annexa 8, Lordship. 22. Out of that, 1 post, Lordship. And after that, it was considered other 28, Lordship. It means out of 50, 28 minus, then it rests 28, Lordship. And after 28, this after 28, it gets 1 post, Lordship. 1 vacant post, Lordship. And it was considered between Milal and the Thakuria, Lordship. And SLC considered Thakuria's case better than Minal, Lordship. It was considered, Lordship. Plumbing, peon, chokidar, helper, and APPO, it will total 28, Lordship. And that 28 is also was also considered, Lordship.
This Thakuria was appointed where? In which post?
Lordship,
So for minus is concerned, it is not.
no, but it is 4th gate post, Lordship.
No, which 4th gate post? Because as per 28,
Lordship.
in Khalasi, there is 1 post.
Khalasi 1 post already it was already appointed, Lordship.
All right.
Yes.
Not by Thakuria.
Yes, no, Lordship, not by Thakuria, Lordship.
Then the balance are all nil.
After deducting 22, Lordship, rest 28, we considered among the rest 28, it appears that 1 post is vacant.
From where? Kindly come to page 28.
Yes, Lordship, 28.
Page 28.
Yeah. Yes, 28, Lordship. It was I think the date was not given, but it was calculated earlier to the consideration of Mr. Thakuria, Lordship.
No.
It is not the date.
That you have to bring it on record. How many posts? What is the, how many vacancies are available? What is the cadre string? Which post you have considered? All these details will be available in your.
Lordship, better it will come from the department, Lordship, the irrigation department. Yes.
No, it will be available in the minutes.
Yes,
the file containing the minutes.
Yes, Lordship. Minutes is there, Lordship.
So the minutes, the agenda for the meeting will contain all these details.
And Lordship, so for minus resolution is concerned, it is also silent against these 2 CSPD comments.
Lordship, yes. This thing. It would have helped before.
Yes.
So far, from the paragraph 4, Lordship, it is clear, Lordship, that total strength, cadre strength of grade 4 is including Khalasi is 50, Lordship. With
we understand what is there, but vis-a-vis the page 28,
Lordship,
which shows the staff position, vacancy position.
Lordship.
Either you say that this is not the correct position, but it contains the endorsements of the department, irrigation.
Lordship.
So the position, the minutes, the SLC will consider the case vis-a-vis the position reflected.
Lordship.
So what is the position reflected by the department, which was before the minutes at the time of consideration?
Lordship.
Where is that?
DLC. That is not DLC. DLC, from DLC.
So it must be there in your file. Records, you don't have the records.
No, I don't.
You clarify on this.
Lordship.
This para 4 statements must be reflected in some staff position.
Lordship.
Where is that?
Connection. Nothing.
Mr. Hart, learned counsels for the parties, Mr. J.K. Goswami, learned government advocate. Has referred to para 4 of the affidavit filed by the secretary to the government of Assam Irrigation Department, Dismissal Guwahati 6, explaining the manner in which the cases of the petitioner vis-a-vis another candidate was considered, and as to why the petitioner's case could not be considered due to lack of vacancies. Stop. These statements made in para 4 reflect that one post in the cadre of Khalasi was already filled up, and no vacancy is available under the 5% quota in respect of the other grade 4 posts, namely peon, chowkidar, helper, and APPO posts. And therefore, the case of the petitioner could not be considered. Stop. In the said paragraph, it is stated that the other incumbent, namely one Sri Ratan Thakuria, was recommended for the single available vacancy. Stop. From the statements made in para 4, it is not clear in which vacancy and for which year the case of the said Sri Ratan Thakuria was recommended, as the averments made in para 4 reflect that no vacancy was available in respect of all the grade 4 posts comprising of Khalasi, peon, chowkidar, helper, and APPO posts. Stop. Mr. Goswami will produce the relevant records on the basis of which the SLC recommended. SLC considered the case of the petitioner in its meeting held on. When was the meeting held?
Page 30.
Why don't you tell us the date?
Lordship,
15/9.
21.
15/9/2021. Stop. These records be produced before the court for perusal of the court on the next date fixed.
After 1 week, Lordship.
Let the matter be listed after on 25th. 25th.
Interim order may continue.
Mr. Mohan appears for the petitioner. Interim order passed earlier will continue till the next date fixed. Will continue until further on. Yes.
May I please. Lordship, this matter relates to compassionate appointment matter. My lord, the husband of the petitioner, while working as laboratory technician under the Joint Director of Health Services, respondent number 5, my lord, died in harness on 5/1/2011. my lord. Thereafter, my lord, petitioner's case was recommended by the district level committee. my lord. And the district level committee have rejected the claim of the petitioner. my lord. Thereafter, the petitioner filed one writ petition, my lord, bearing writ petition number 4721/2014, my lord, before this honorable court. And by the order dated, my lord, 18/3/2019, my lord, this court directed the respondent to place the case of the petitioner before the appropriate DLC. my lord. And on, my lord, 24/12/2019, my lord, the DLC, my lord, recommended the case of the petitioner, my lord, as per page 29, my lord, DLC's recommendation. Page 29.
Yes.
DLC has recommended the case of the petitioner in the year 2019, my lord. But till date, the case of the petitioner has not been placed before the appropriate SLC. So the simple prayer before your lordship would be, my lord, that the case of the petitioner may be placed before the appropriate DLC. my lord,
Yes.
in
What
its
do you say?
next available meeting.
Who will be the SLC?
By sending it.
Lordship, instruction is still awaited, Lordship. Actually, Lordship, now only I got a extra copy, Lordship.
We are disposing it of. You, if not placed, you place it.
Lordship.
If already placed, you furnish a copy of the orders. We will pass orders on this.
I'm highly obliged,
That disposed.
Nice, Lordship.
And mark a copy to the office of the respondent. Yes.
This is one for grant of the benefits of the assured career progression scheme as it was then implemented in the year 1999, and thereafter the provisions of the modified assured career progression scheme as it was introduced in later on. So the petitioner was serving in the Central Central Industrial Security Post.
Who's for the respondent?
The Union of India is to come. Titiya asle ar bora. Ranu bora bari. FTP by Ranu bora.
Huh? Green paper. Acha. Green. I may be allowed to call it the green paper, my lord.
So may I place it this way? If it is taken up on Monday or Tuesday, I will have to place the promotion rules of the CISF and the
All right, for
ACP.
admission hearing on, give a date, please. Admission hearing. 21. 21, for admission hearing on 21. Names of the CGCP reflected in the course list. Mr. R. Mozumdar for the petition. Yes.
And when my lord, the specific advocate was called for, it's not next date make it. Another case.
What is your prayer?
Lord, actually, I am not in the case, my lord. The Angus advocate, he has another matter in court below, my lord.
Then we'll close it. He is not interested.
Okay. The backlog.
Yes, Mr. Goswami.
Lordship. He will come, Lordship. I informed them.
Who will come?
Is it item 7?
Seven.
Item 7, Lordship, here in this case, Lordship, is a physically disabled persons, Lordship. Now, originally it was in the social welfare department, Lordship. Now the department was segregated, Lordship. It is social justice empowerment, Lordship. And on behalf of social justice empowerment, Lordship, the RL does the standing council is appearing, Lordship. And therefore, I had already informed Lordship, he will come. Lordship.
All right, then take it up next week. Then it councils appearing for the parties are not available in court. Matter stand adjourned for 1 week. 1 week.
My lord, his name may be shown, my lord.
Why should the name be reflected? The councils have accepted responsibilities, they will come. Yes.
No, please, your lordship. Lordship, I have received the instruction from my client. There is no objection if the department has taken a decision regarding her voluntary retirement and her pending salaries, lordship, as per which are legally due to me. I could not continue in my service from June 2014.
You submitted some voluntary retirement.
Yes, lordship.
Yes, Mr. Counsel for respondents.
Lordship, department has filed their affidavit. As per their affidavit, as page 2, paragraph 7, lordship, there is no voluntary scheme in the department. So they will constitute a committee and it will stand for the government. That is this
Paragraph number?
paragraph
7.
number 7, lordship.
So the committee is in.
Yes, Lordship, and the committee meeting was held on 18th of August 2021. The proposal is there, Lordship, with regard to the voluntary retirement scheme. So Lordship may dispose it off with the direction to take a call with regard to the contention of the petition.
It is placed before the committee.
Yes, Lordship.
What was the decision of the committee?
The decision, Lordship, there is no such decision, final decision has not been taken.
Why?
With regard to the scheme, because the scheme, there's a draft is there, but no final decision has been taken with regard to the VRS. But for the work charge employees, some decision has been taken, but for these people, Lordship, no decision has been taken till date. But the process is on, Lordship. There is some process has been initiated to take some sort of decision with regard to the VRS scheme, Lordship.
So what is your prayer?
Lordship, to allow me the application for the VRS as urgently, Lordship, because I need the money also. I'm totally ill, Lordship.
No, your application for VRS, there is no scheme for VRS in the board at that point in time. Now they are in the process of trying to set up some committee or some VRS, but it is not finalized yet.
That can be finalized urgently, Lordship.
We can't direct them to finalize if they don't want to. Only if it is finalized, we can direct them to consider your case.
Exactly.
What is the status?
Status, Lordship, the instruction that I have received is still pending. The committee.
What is pending?
Yes, Lordship. And the meeting was held in the month of August 2021.
No, what is pending?
The pending with regard to taking a final decision with regard to the scheme.
VRS scheme itself.
Yeah, VRS scheme. No decision has been taken. The last
Then-
instruction that I have received as per that instruction.
Then we'll have to hear the matter. Madam,
Yes.
there is no finality in this
Yes.
decision as yet.
Lordship, in that case, may I pray then? I have stated in my petition that some salaries are due to me. Let them calculate it, Lordship, which is legally due to me in my service period, Lordship. that
What is legally due to you will have to be determined, taking into consideration the services you have rendered. Now, on the date you have submitted your application for voluntary retirement, you are not working.
Not working.
So assuming there is no voluntary retirement acceptable or accepted by the department, then this will be construed to be a misconduct. And there will be some departmental proceeding may be initiated.
Yeah.
Subject to the proceedings, what conclusions are arrived at by the inquiry committee,
Yeah.
accepted by the disciplinary authority, the question of what is payable to you will be determined. But as on date, you are not working, so there cannot be a prayer for releasing current salaries.
no, Lordship, I'm not.
You are
paying
not
current
getting your salaries from which date?
Lordship, they have stopped my salary. uh, June 14, Lordship,
Which year?
2014, June.
2014. And you are on leave since when?
After that, Lordship, since June 2014, I could not.
So that leave, whether it is authorized or unauthorized, some decision will have to be taken. So if the authorities don't want to take, if you want us to proceed in the matter, we'll take it.
Let them take a decision, Lordship, then keep my petition pending, Lordship. Otherwise,
No, we can't do that. Either we proceed with your hearing or we close it. Yes, Mr. Counsel.
Also in the affidavit in opposition, paragraph number 5, it is specifically mentioned that the petitioner frequently used to apply for leave on medical ground during a service tenure, and the petitioner remain unauthorized absence for 686 days.
Whether it is authorized or unauthorized, what is the basis? On what basis do you say
No,
so?
it has been mentioned in the affidavit in opposition. If you also kindly see paragraph number 5. During a service life, she applied various nature of leave, which was accumulated altogether will be 917 days. Out of 917 days, the concerned authority was sanctioned, has sanctioned 231 days leave to the petitioner. The petitioner remain unauthorized absent for 686 days.
For these 231 days, her salary has been released.
So that has been done. And that is the reason why it has been mentioned that the unauthorized absence for 686 days, and there is no application. Nothing.
You think over it, madam. We'll
because in my
keep
petition,
the matter for admission hearing.
Lordship,
Matter be listed for admission hearing. Give a date.
It has some difficulty, Lord, after treatment.
Yes.
Thank you very much. Lordship, the background of the case is that the petitioner husband, Lordship, because of unauthorized absent, Lordship, he was dismissed from service. But without serving any notice, Lordship, to the delinquent, Lordship, he died. But the present petitioner is the wife of the dead released employee, Lordship. In the office of the Learned Session District and Session Judge Haile Gandhi, Lordship. Lordship, first on coming, Lordship, page 20 is the so-called notice, Lordship, of the repetition.
Now, what are your grounds for challenge?
Ground for challenge is that, Lordship, the no notice, Lordship, nothing was served, Lordship, to the as per the DP while doing the DP, Lordship. That notice was not properly served to the said delinquent official, Lordship.
employee, Lordship. Page 31 is the
No response filed, Mr. Nair.
My lord, this matter was heard. I was asked to take the instructions. The instructions were met. I placed that, but the matter could not be taken to its logical conclusion. The whatever is there, my lord, it's there on record only. What we have done, my lord, he had given an address in his service book. When, my lord, he was not coming to the office, we sent messages to him at his, my lord, residence. He was not found there. The process server, my lord, went, search was not found. Thereafter, proceedings were initiated. That was also intimated through this process and thereafter in the newspaper. But, my lord, there was no response. 2011, this was done. 2013, the wife files an FIR saying that he is missing. Then, my lord, we conclude the proceedings, terminate him, and as because, my lord, his addresses were not known, this was published again in the paper. The matter ended there, my lord. In 2017, what happened, my lord? There is an FIR file that, if my lord can have page 37, my lord. Page 36 is the removal order.
Yes.
this is, my lord, removal was in 2012, my lord. 2017, what happens, my lord, will have page 37. This is to report that on 4/5/2007, one Gautam Das, son of so-and-so, lodged a written FIR as per so-and-so that on 1/5/2017, at about 2 p.m., there was a fire incident took place at Messrs. Govindananda store, which belongs to his first cousin so-and-so, and one of his staff, namely Biswa Ranjal Gosal, that is the husband of the, my lord, the petitioner. Alias Bisu, 45 years, so-and-so, was sleeping inside the godown of the store. At the time of fire, he got severe injuries on his person and he was shifted to GMCH for treatment. And on arrival, the MOM duty declared him dead after checking. So, my lord, in 2017, he was working with some other person in that. So, my lord, these things were known. Now, after his death, the wife has now come up claiming for, my lord, his pensionary benefits. Then we informed her that he had already done. Thereafter, this case has been filed, my lord. Whereas the matter had attained its finality.
Is he the same person?
Same person. Their repetition, my lord. So, my lord, he knew about it. He willfully stayed away. And thereafter, my lord, now, my lord, the problem here is when the employer does not have an access to the employee, we went to his house. And the most interesting factor here is we have in our letters given an address, my lord, that she was there. They have not disputed that this is not the place where we reside normally. We reside at so-and-so place.
No. Mr. Mazumdar, is he the same person?
Lordship is the same person, Lordship. But
So if he is the same person,
Lordship.
do you deny the fact that he was working somewhere else?
No. He was not working. He was missing, Lordship.
What
With
missing?
all respect, Lordship, kindly, Lordship, before that, it was all subsequent, Lordship. Prior to that, how he was entered, DP was done, entered, charge was paid, Lordship, nothing,
No, he was missing when? From which date to which date and why was he missing?
Lordship, I'm coming, Lordship, on that. Just, Lordship, page 20, may kindly, Lordship. Page 20, it's a shock cause notice, Lordship.
No, you said he was missing.
Lordship, I'm coming, Lordship. On that, Lordship, just I'm coming, Lordship.
Page 25 is the FIR with regard to missing, my lord.
Missing, Lordship, I'm coming, Lordship, that. Prior to that, Lordship, just how the entire thing was done, Lordship, that I am just want to place to the Lordship. Since my learned friend has not filed any affidavit on the merely stating that you are serving at other places, that was not known to us, Lordship.
No, this is in the FIR.
And that's in the writ petition.
And Lordship, page 20, may Lordship kindly peruse, Lordship, it was a notice issued to the office address, Lordship. His office address, Vishwaranjan Gosal, Office of the District and Session Judge. Page 20, Lordship.
No, I think Mr. Nair, you'll have to file some counter.
I'll do that, man,
Because
because the
you-
matter was
you-
taken up for hearing without this. So we
because you'll
proceeded,
have
my
to-
lord. I'll have it filed, my lord.
You'll have.
And
to-
my lord would have one
You'll have to get
sequence.
you'll have to get the details because apparently some FIR was filed.
My lord, FIR was filed. There is no dispute on that. If
Showing
lordship is at page 20,
25.
no, my lord, before that, if your lordship can just come to page 36 for a moment, my lord.
Yes.
This is, my lord, 10/2/2012. On the strength of the final order dated 4/2/2012 in DP number so and so peon of this removed from service on so and so, as his whereabout is not known to this office, the aforesaid order be published in the thickly circulated newspaper. Saristadar of this office is directed to take necessary steps in this regard. In my instructions, my lord would find that order. Now what has happened, my lord will have now 35 to page 25. My lord. The publications were made in 2012. Thereafter, my lord would see at page 25. I beg to state that I am the applicant above named, that the below mentioned named person is my husband, was untraceable since March 2011 with my below named daughter. After repeated search, I could not trace my husband and my daughter. I therefore pray that kindly do the needful in the above matter as per law. Finished, dated 37/2013. Now, my lord would see the police report at page 29.
29.
29, my lord.
Yes.
With regard to that GD entry. This is to certify that one so-and-so, Hailakandi reported at PS stating that in the middle of the month of so-and-so, her husband so-and-so aged about 45 years, fair complexion, and her daughter so-and-so alias Pinky aged about 12 years, fair complexion, has been missing from the house. It is reportedly learned that the missing girl is presently staying in the house of one Johelur Gumar, alias Debin of Senimari Tiniali PS Moriani under Jurat district. The informant along with their relatives proceeding to Moriani to bring the missing child kindly render necessary help. So that is there in 2014.
That is the child.
Then my lord would find he had, my lord, gone away on his own, maybe some family tussle.
Maybe.
Then my lord will have 37. They have not disputed these facts, my lord. 37, my lord. This is the fire incident of 4-5. My lord would find 1, 2, 3, 4 belongs to his first cousin so-and-so and one of his staff, namely Biswaranjan Gusar. So he was working there in Meherpur, my lord.
No question of.
And these things were never disclosed to us, man.
Lordship,
No,
the
how,
notice.
how will it be disclosed? He is not even participated.
Lordship,
Not even participating, my lord.
even
So
notice.
we'll have to, my lord, wait.
Let me clarify one thing as subject to my learned friend Lordship.
Is there no procedure for lodging an FIR for an employee who was?
My lord, normally it is not done. We give it in first we gave it in a paper asking him to rejoin back. No, nothing, my lord.
Lordship,
And
no
the
registered
removal
notice was
order
served.
led to that
No
FIR of
registered-
2013.
No service Lordship, that process server Lordship ought to have hanged this notice Lordship because that notice was in the official address.
Where is the process server report?
A report,
Lordship, I'm
process
coming,
server
Lordship.
report, my lord would
Page
find.
22 is the vernacular English.
21.
21. May I read the
21.
Bengali version Lordship or English Lordship? That is 21. Lordship, the notice of the address Lordship is the office of the
But it
district.
is your case that you are missing.
Lordship, my restricted submission, since the notices were not received by the victim, that is the delinquent.
You are missing.
Lordship,
That is what your FIR of your wife says.
Lordship, it was subsequent. That
How can it be
not-
subsequent? March 2011.
That was
2011.
26/5/2011, Lordship, the SOCOS was issued on official address.
Kindly come to page 25.
Lordship,
This is an FIR filed by your wife
Lordship,
alleging that you were
And-
missing since March 2011.
Lordship.
And this was
And
never,
the process server had gone to serve you on 35
Lordship,
and 1/6.
Lordship.
So you are missing.
Lord-
So where is the
But
question
other
of
family members, Lordship, my other family members are there.
the
As
other
per the
family
CPC, as
members?
per the High Court rule, Lordship.
We don't know that, but to say that you did not receive notice
Lordship,
is self-defeating in view of page 25. It is your FIR.
Lordship, I am not on that lordship, entire lordship proceeding. Lordship entire address was on official address. That legal notice lordship in the paper also, no mention about the address of the delinquent lordship. It's in Banikula, Bishopur Jilla, Daira Judge Karjalaya, Hailakandi. Not mentioning any address of his home address.
Who would have participated? Tell us.
Lordship, at least the family members.
Family members will be able to participate in a disciplinary
Lordship,
proceeding.
they will have to intimate the things what has happened, Lordship.
Mr. Mazumdar,
Lordship.
you are missing since March 2011. You are not denying that statement.
Lordship. But my restorative submission only that whether that notice was properly served or not.
No, notice properly served or not would be relevant,
Lordship.
subject to you denying the fact that you are available in your residence.
Lordship, that part and since they have not filed their affidavit also.
Perhaps they don't need to file an affidavit.
And
That was the conclusion on the last occasion also.
Lordship,
That we can proceed.
just Lordship, I should try to satisfy your Lordship on
There is
that.
nothing to satisfy.
Lordship, only question is that whether the notice was properly served. As per the rules says, Lordship.
What are the allegations in the,
Lordship,
Malay,
kindly,
it was
kindly
Malay-
page 31. Let me submit. My learned friend by turn, he will submit, Lordship. With all respect, Lordship.
no.
Let me submit page 31.
What
With
are
the
the
final order.
allegations? You have remained absent.
Lordship. DP was initiated against so and so delinquent, so and so. The matter was brought to the notice.
So
and
the allegation is that you are absent,
Lordship, unauthorized absent.
unauthorized. Now, who will prove to the contrary? Your wife.
Wife or other family members
What about what?
about the
That you are present in your office?
Lordship
How?
or without presence, Lordship, the what about the sequence to that Lordship to be
What sequence? The allegation is that you are absent from your office.
Lordship. And the
This fact is evident from, there must be a register.
Lordship.
Mr. Nair,
Yes, your lordship.
the attendance register will reflect that you are not there.
And
Just-
paper notification was made asking him to come back.
Let me submit. Please. I may be allowed to Lordship. Page 32. Just a shockos was issued to him by the officer so and so, but this.
You are, Mr. Counsel, we are not dealing with a title suit.
No, Lordship. On
We
that.
are exercising writ jurisdiction.
Lordship.
So the question that the court wants to ask you is that you do not deny the fact that you are missing
Lordship.
in FIR lodged by your wife.
I'm only.
Allegation against you is that you did not attend your office, unauthorized.
Lordship. That my restorative submission only on that.
Natural justice is not an empty formality.
No. I am not on that, Lordship, regarding, I am relying on judgment 1998.
No, judgment will look into all your judgments, but satisfy us on the facts.
Lordship, that notice to Lordship, at least the other family members, parents, family members are there,
To
Lordship.
what effect? What
Lordship,
will they prove?
address,
What will they prove, assuming the notice was served?
at least they will intimate that that person is missing, Lordship, the authority, the feedback of
So
that.
if they're missing, assuming they're missing,
Lordship,
then also some order will have to be passed by the authorities.
Lordship. At least they can, Lordship, only on issuance of that.
What is the stage of the police investigation in respect of your FIR which you have filed?
Nothing, Lordship.
Then
That.
what steps have you taken?
Lordship,
What steps have you taken?
after death, Lordship, while get the information, Lordship, in the Lordship there. But regarding that investigation of that.
You are an astute counsel, you know
Lordship,
that there has to be some finding of some authority
Lordship,
acceptable in law
Lordship,
that this person was indeed missing for 7 years or something and presumed dead.
Lordship.
Where is that finding? By
That-
which authority?
The from the police, Lordship, that subsequently, Lordship, that their Lordship, which was happened in Silchar, Lordship, Lordship, he was
There he is identified as an employee.
not an employee, Lordship. With all fairness,
You
Lordship, there was
cannot
no
accept-
contact with the
You
family.
cannot accept a part of the report and reject the others. Either you reject the
I'm
report,
only on that, Lordship, regarding the notice, Lordship.
that is an empty formality.
And that Lordship, I'm relying on judgment, Lordship, of that, kindly consider, Lordship.
98.
1998 7 SCC 569 Lordship. Because there was, that notice was never sent by registered post or any postal address, Lordship.
What is the facts involved in the case?
Lordship.
In
Facts
this,
of
in
that
this,
case,
in this matter?
in this matter also like that, Lordship, the notice was.
No, then what happened? Why? What were the allegations?
Not found. Lordship. Vital paragraph is paragraph 3, last portion, Lordship. Paragraph 3, page 575, Lordship. May I read, Lordship? The appellant should have made further efforts to serve the charge sheet and on the respondent. The single efforts in the circumstances of the case cannot be treated as sufficient. That being so, the very initiation of the departmental proceeding was bad. It was expert even from the stage of the charge sheet, which at no stage was served upon the respondent. So far as the service of the show cause notice is concerned, it is also cannot be treated to have been served. Service of this notice was sought to be effected on the respondent by publication in the newspaper without making any earlier effort to serve him personally by tendering the show cause notice, either through the office peon or by registered post. There was no such.
These facts are different from your.
Lordship.
Here a process server was there on 2 dates.
But
It can be a single attempt.
there was a single attempt in that sense, Lordship.
2 dates.
I am coming just, Lordship, with all respect, kindly bear me, Lordship. With all fairness, I should try to keep Lordship on that also.
We'll bear with you another day. Let him file the.
Let him
response
file the affidavit, Lordship, so that I can get a chance to file.
So that you will not have a ground in appeal to say that you were not given an opportunity of rebutting.
Matter is pending a long backlog.
Therefore, we wanted to pass an effective order.
When the matter was being continuously heard before court number 6, my lord, the matter was proceeded in this, that there will be no affidavits because the materials are on record. That's why the affidavit was not filed. The matter did not come up thereafter for a long time. I'll file an affidavit.
Bring it on record.
I'll bring it
so
on
that
record.
if there is anything for Mr. Mazumdar to rebut, he will.
Sure, madam. I'll do
if he
that.
wants to.
Or the only fear, my lord, in such cases is if this, my lord, gives a seal of approval, tomorrow, my lord, in such situation, the person delinquent, my lord, who knows he'll be removed, he'll just vanish, my lord. And thereafter, after his death, the wife will come up. That should not be, my lord.
The rarest of the rare case, Lordship. Where
No, let us, for the sake of arguments, let us assume that we allow your writ petition.
Lordship.
We cannot hold that you are absolved of the charges. The most we can do is to go for a de novo proceeding.
Lordship.
Who will participate in the de novo? The wife?
He is no more, Lordship.
The wife?
No.
How will she explain?
Not possible.
But since this is kept in the file, Lordship, entire order, Lordship, that was also not, dismissal order was not communicated.
No, it was done through paper, madam.
They have done through a process server.
Let me, Lordship, explain, Lordship.
You even did not make any attempts to find out whether process server was actually that report that
And
steps
Lordship, with
were
all
taken or
fairness,
not.
Lordship, he should have to, as per the service process of the CPC as well as the High Court rule, he should have to take, while he has visited the house or anywhere, he should have to take signature of at least 2 persons, Lordship. Here is not, Lordship. The service is not at all proper, Lordship. With all fairness, I am submitting, Lordship. With all fairness, I am submitting the dismissal order.
is in the house.
Maybe other locality peoples are there, Lordship. If suppose, Lordship,
Who stayed in the house at the relevant point in time? Husband and
with
daughter
all
were
fairness,
already.
Lordship, he has visited entire area, then why not a proof should be as per the CPC, Lordship, and the service process, as well as the High Court rule says he should have
Some
to,
lacuna, yes, he should have
take signature of the
signature
person,
of
Lordship.
some person of the locality.
Locality, Lordship, on
pasted
the
in
road,
house
Lordship.
Or something like that.
Enter my respect to submission, Lordship, entire notice was on office address. Never, Lordship, issued any notice to the residential address.
Therefore, the
No-
query from the court that assuming we remand the matter, now what happens?
Lordship, I am not on, Lordship, if she is having 2 child, Lordship, he is on the state. With all fairness, I am submitting. I'm Lordship,
All right,
though my
Mr.
learned friend is saying something that so
Mr.
many
Nair will
blood-
file the affidavit within
2 weeks.
2 weeks from
Lordship.
today.
Because
Heard.
I'll not hesitate if Lordship, with all fairness, I'm submitting, she is on the street with having 2 child, Lordship. And this
That's
husband,
all right,
Lordship,
but-
everything
but-
is a poor process server. And that will not have open a blind rate as my.
It is not your claim that he has not been receiving his salary also.
No.
Lordship,
Since 2011, when he had disappeared.
Lordship.
It's not your claim that his salary has been stopped. He has not received his salary.
Lordship, while she is getting all these Lordship records from the office, that was supplied by the office, Lordship, while after the death.
We gave her, when she came, my lord, we gave her everything. my lord.
All right, heard the learned counsels for the
So,
parties.
all fairness,
Mr.
I'm submitting.
Mazumdar, senior counsel, assisted by Mr. So-and-so,
MP
Mr.
Sharma.
Nair, assisted by
Mr.
Mr.
MP Shaw.
MP Sharma. Mr. You are appearing for the respondents.
I'm for the respondents.
The respondents will endeavor to file the affidavit in the matter as certain factual aspects are involved within 2 weeks from today.
Lordship. Respond number 2 and 4, 2, my lord.
If
2 and
Mr.
4.
Nair appears
2 and
for
4.
respondents,
2 and 4. my lord.
and Mr.
3, my lord.
Goswami for
3,
respondent 1.
3, my lord. Then the respond number 3.
3 is also missing.
Missing.
Sorry, Lordship, it was tactical error, Lordship. It may be 3, Lordship.
Doesn't matter, it is 4, so we have reported it. 4.
Lordship, I may be allowed to correct.
Not necessary. Let it be 4.
Sorry.
When the matter first came to me, I was under the impression that this is something which should be done. But when they started giving me the informations, my lord, I found that no, this is a chance they're taking, my lord. That's the only thing, my lord.
They are taking Lordship as small guys on heavy Lordship. Lordship. But for maybe Lordship, I much obliged, Lordship, sorry.
Well, this matter pertains to promotions to the post of account officer. The last occasion, my lord, during the course of hearing, my lord, some confusion arises regarding as to whether there is a service rule of PNRD is in existing or not. I have inquired, my lord, there is no service rule so far as, my lord, the PNRD department is concerned. Though they have prepared a draft rule, but it has not been finalized. So my claim is that, my lord, I was appointed in the year 1996 as an accountant cum storekeeper. Whereas the parallel department, the DRDA, the then DRDA, my lord, which was dissolved in the year 2017, the same person, my lord, with the same qualification, who were appointed as an accountant cum storekeeper, has been subsequently been promoted to the accounts officer. So I've been stagnating in the same post since the year 1996. From 2011, I started submitting representation before the authorities, and some of the authorities also were on the decision that I should be promoted. So they started the process. And there was a discussion which is reflecting in the note sheets, my lord, that after the DRDA is amalgamated with the PNRD department, my prayer for promotion would be considered. But thereafter, nothing has been done. And on 28 May 2020, which is available at page 33, I have been given a promotion to a post of assistant account officer, which is described as a redesignated post. And while doing so, my lord, my grade pay has been reduced. Earlier, I was drawing, my grade pay was rupees 8,000. Now the grade pay has been reduced to 7,600. My only contention, my prayer is that, my lord, if I am at all eligible for the post of accounts officer, though there is no service rule in the PNRD department and there is no hierarchy of post, but so far as the DRDA is concerned, they had their hierarchy of post from storekeeper to senior accountant and then to accounts officer with a higher grade pay. So I, being the person appointed on the same day along with the other persons, I am also entitled to get the promotion because there cannot be one.
The other persons got their promotion in DRDA.
DRDA. This is one.
Now you are claiming promotion after the DRDA is merged in the PNR.
PNR. And subsequently, they have issued a notification which is available at page 44. They have created a post of accounts officer, 24 numbers of posts in the entire state of Assam.
Now, how are these supposed to be filled up?
Well, these posts are to be filled up on the basis of the qualification and the experiences. And I am told that, my lord, out of 24 numbers of posts, 13 posts are still vacant in the department. So if at all I am eligible and have the required qualification and experience, my case may be considered.
Yes, Mr. Kaur.
From my affidavit, it appears that he is not a DRDA born employee. He's a government employee also.
Huh?
And
He's a government employee.
yes, Your Lordship, from my affidavit, Your Lordship.
Your affidavit is respondent too.
Yes, Your Lordship, yes.
Page para 5.
Para 5, Your Lordship.
He says it is he's a DRDA board employee.
Whereas the paragraph 5, Your Lordship.
Petitioner is a government
Second
employee.
paragraph. Whereas the petitioner is a government employee and holding a permanent officiating post and governed by the Assam Panchayat and Rural Development non-gazetted is a draft rule. So since he is a government employee, Your Lordship, so Your Lordship, the DRDA
He is a government, he was appointed under PNRD.
yes, so initially he was working as per his pleadings, Your Lordship. Initially he was working in the Deputy Commissioner's establishment.
Where is your appointment order, initial appointment?
That is not annexed, Your Lordship.
That has not been annexed.
Why? Then
His, Your Lordship, his initial appointment order, how he came to the PNRD service, those appointment orders are not annexed, Your Lordship.
you'll have to get it.
He is only relying on.
He was
certain
initially
communication.
appointed as an LDA.
Yes,
Some
my lord.
typist.
Under the deputy commissioner's establishment.
So you were governed by the district establishment rule.
Thereafter, out of arrangement, I was taken to the Department of Panchayat and Rural Development, whereby the arrangement was I would be given a promotion to the post of accountant cum storekeeper. So subsequently it was done. So I had been working since 1996 in the post of accounts officer cum storekeeper.
See, these orders, where are
But
these?
these orders are not some. I have also seen in the petition. I have subsequently entered in this case. So I have seen there are
You
appointments order.
bring it on record. You
But from
bring
the
bring
various-
those documents on record.
But
So that if required, we can direct the government to find out the status. So now he's presently again come back to PNRD.
Your Lordship, PNRD has promoted him.
Where
Page
is he
33 of the
working?
writ petition, Your Lordship.
Where are you working now?
But in the block development, my lord, Pathargandi.
Subsequently, he was promoted to the post of assistant accounts officer.
It's a redesignated post. While doing so, my grade pay has been reduced, which is also prohibited under the ROP rules.
Lordship, from my affidavit, it appears that his earlier grade pay was 7,400. Now this is 7,600. He is claiming that earlier his grade pay was 8,000.
In the affidavit, in most of the paragraph, there is no reply, whether I am
Yes,
entitled, whether under para 7 says my contention in para 8 has never been dealt with.
Yes.
And in this regard, since the commissioner, principal secretary is the appointing authority, the affidavit from his side also is of importance.
We will file from the government. Principal secretary.
Now, what is the status of the rules?
Also, Lordship, it is in the draft stage, not yet enacted.
You can implement the draft rules also. We can Close the matter with a direction to examine his grievances
Yes.
vis-a-vis the rules which are in the draft stage. And you pass an order considering his claims. Okay. You were initially appointed as
LDA come, my lord, under the Department of
typist.
LDA come typist under Department of District Administration. Then in the 1996, out of an arrangement, entered into the PNRD. I was appointed as accountant and storekeeper. And since that, my lord, till I was given the promotion as a in the redesignated post, I was stagnated in the same post.
No, yeah. After you were transferred to DRDA, you were promoted as an accountant.
But I was not transferred to DRD.
Then
Plus, I was all along working under the Department of PNRD, my lord. I am claiming the parity, my lord, with the DRD employees because they have their own rules and promotional avenues. So far as PNRD is concerned, there is no promotional avenues. So I am basically aggrieved by that. My lord.
Yeah, so far as DRDA is concerned, they were appointed under a scheme, the DRDA born employees. And it's the agency, your lordship, registered society.
all right, we'll pass orders at 2. At 2. Heard learned counsels for the parties. This writ petition is filed by the petitioner. Who is aggrieved by the non-consideration of his case for promotion to the post of accounts officer. Stop. Petitioner was initially appointed as lower division assistant cum typist in the year 1988 under the amalgamated establishment of Deputy Commissioner Kachar, and he was posted in the block level office. Stop. After about 8 years of service, petitioner was promoted to the post of accountant cum storekeeper and was posted in Karimganj, Mahkuma, Porikot under the PNRD department. Stop. Subsequently, petitioner was transferred to Patharkandi development block and then to the Kachar Zila Porikot. Stop. Petitioner was again transferred back to Patharkandi on 21/09/2011. You're working in Patharkandi now?
Patharkandi.
It is it is stated by the petitioner that the post of accountant cum storekeeper to which the petitioner was promoted, there is equivalent pay scale to the post of accountant under DRDA. Stop. The accountants who were working under DRDA were promoted to the post of senior accountant and subsequently were further promoted to the post of accounts officer. Stop. The grievance of the petitioner is that although the accountants under DRDA drawing the same scale of pay were drawing the same scale of pay with the same educational qualification, were promoted initially to the post of senior accountant and thereafter to the post of accounts officer way back in the year 2011, the petitioner has been stagnating in the post of accountant cum storekeeper for more than 25 years and without any promotional avenues. Stop. Being thus situated, he filed a representation dated 9/6/2013 before the Secretary, Principal Secretary, PNRD Department, with a prayer to upgrade him to the post of accounts officer. Stop. In response to the representation furnished by the petitioner, the government requested requested the block development officer, Patharkandi Development Block, under which the petitioner is serving, to furnish copies of his service book, appointment order and other respected related documents. Stop. However, no such order has been passed on the representation preferred by the petitioner by the competent authority. Stop. Since no information was forthcoming from the competent authority, petitioner filed an RTI application. Stop. From the documents made available to the queries raised by the petitioner under the RTI, petitioner came to be aware that there was a proposal which is being considered at the appropriate government level to consider cases of the petitioner only upon amalgamation of the DRDAs to the Zilla Pariষদ. Stop. From the documents made available to the petitioner, he came to be aware that his case will be considered upon amalgamation of the DRDAs to the Zilla Pariষদ. Stop. Thereafter, the DRDAs were eventually amalgamated with the Zilla Pariষদ by government notification dated 29/07/2017. Stop. In terms of the communications made available to the petitioner under RTI, he was expecting that his case for promotion will be now considered by the competent department in the government as the DRDAs have been amalgamated with the Zilla Pariষদ. Stop. However, in spite of his repeated requests, the case of the petitioner has not been considered. it is the submission of the, it is the case of the petitioner that although he was initially sought to be shown to have been promoted to the post of accounts officer. However, in reality, the post which he was promoted within quotes was a redesignated post of assistant accounts officer. Now was to the post of assistant accounts officer, which was redesignated as accounts officer. Stop. Be it as it may, the petitioner came to be aware that the department has accorded approval for sanction for creation of 24 numbers of posts of accounts officer in the Zilla Porikot under 6 scheduled districts. Stop.
Zilla Parishad and DRDS under 60. DRDS under
DRDS and Zilla Porikot under 6 schedule.
DRDS
DRDS are amended,
But in-
sorry, amalgamated.
But in the 6th schedule, it is there.
Okay.
6th schedule area.
It is further submitted by the learned counsel for the petitioner that insofar as 6 scheduled districts are concerned, the DRDS functioning under the 6 schedule have not yet been amalgamated with the Zilla Porikot. Stop. Para Mr. So-and-so learned counsel for the petitioner submits that as on date, how many posts are filled up or
Yeah.
available?
To my information, none of the posts are filled up.
Submits that as on date, although the posts have been sanctioned, none of the posts have been filled up. But the competent department in the government, but the matter is under active consideration at the appropriate level in the competent department in the government. Stop. He therefore submits that his case for consideration for promotion to the post of accounts officer in the newly sanctioned posts under the Zilla Porikot and DRDA under the 6th schedule be given due consideration and appropriate orders be passed. So, Mr. A more learned additional AG submits that some draft rules were there.
Your lordship, the draft rules is there. It is so far as his contention is that your lordship, his case is never considered. Your lordship, the office order dated 20th of May 2020, whereby he was promoted to the post of assistant accounts officer. So it was considered and given the benefit to him. And he was working in the post which was not having no promotional avenues. So subsequently, he was promoted to the assistant accounts officer. So far as the other posts are concerned, he is claiming accounts officer. Those were entirely a scheme was formulated to accommodate the DRDA employees. Since he is the government employee, your lordship, and he has given the benefit of promotion by way of the order dated 28th of May 2020, your lordship.
So how about the
Now,
lower grade pay? And
No. Our affidavit says that.
Mr. Or learned additional AG, relying on the affidavit filed with the department, submits that the petitioner's case has been given due consideration. And he was promoted to the post of
assistant accounts officer.
Assistant accounts officer.
Redesignated.
Stop. Is it accounts officer redesignated or assistant accounts officer?
Assistant account officer. There was no such post, neither in the DRDA and in the
Your
PNL.
lordship, the DRDA.
Which post is redesignated?
my lord, assistant account officer.
Redesignated to?
My lord, it is from accounts officer, my lord, this assistant accountant to assistant account officer.
Accounts officer was redesignated into assistant account.
No.
Then?
But it's a post below the accounts officer, my lord, in between accountant and accounts officer. Like in
Yes.
the DRDA, there was a senior accountant. Here it has been redesignated as
Your lordship,
assistant.
kindly see your lordship, so far as DRDA is concerned, it was,
No, we are only
The-
recording whatever is there.
yes.
That's all.
yes, yes.
We're not giving a decision on that. Submits that case of the petitioner has been considered and he was given promotion due to him in the post of assistant accounts officer. Stop. They're referring to the averments made in the affidavit. Mr. Moore submits that the DRDA is an autonomous body,
DRDA was a registered
was
society,
a registered society,
Registered
an
society.
autonomous body,
and its employees were appointed under a scheme, your lordship.
and the employees in the DRDA were appointed under a particular scheme applicable to the DRDA. Stop. Insofar as the petitioner is concerned, he was a government employee holding a permanent post and is governed by the Assam Panchayat Rural Development Non-Gazetted within bracket class 3 and class 4 bracket close employee service rules. Stop. But these are the draft rules.
Draft rules,
Then
your lordship, kindly see, he's the government employee.
he's
And the DRDA employees are,
he's government employee
He-
governed by
how
which
he-
which set
how-
of service rules?
my question is that how he can claim benefit under the DRDA? If
He's a
Yes,
government.
kindly see, your lordship, so far as DRDA employees are concerned.
I
they are-
understand your submission. You listen to the query of the court.
Yes, yes.
He's a government employee
Yes,
covered by which rules? Service rules.
your lordship, since there is no service rules, their services now continuing under the executive decisions, your lordship.
All right. All right.
But so far as the DRDA is concerned, that basic difference is there.
Is
He is
it-
working in a pensionable job and they are working in a non-pensionable job, your lordship. That is
He
the
is
difference.
holding a permanent post governed by is a permanent post under the government of Assam. Strike those the rules. Mr. Moore, however, submits that there is no service rules which governs the service conditions of the employees like the petitioner at present. Stop. However, a draft service rules being Assam Panchayat and Rural Development Non-Gazetted Class 3 and Class 4 Employees Service Rules 2020 has been prepared, but the same are pending approval at from the competent authority in the government. Stop. But as on date, service conditions of the employees are governed by executive instructions in the absence of any specific service rules. Stop. Mr. Kumar further submits that the benefits given to employees under DRDA cannot be given to the petitioner in as much as the petitioner is a government employee and holds a civil post, which is also pensionable. Stop. However, those employees under DRDA were employed under a particular scheme and are not employees under the government. Stop. As such, unless the rules are finalized, no specific claim for promotion as such can be made by the petitioner by by making references to the promotions given to employees working under DRD, as the nature and class of service of the petitioner and the employees of DRDA are distinct and separate. Stop. Learned counsels for the parties have been heard. Readings on record. are carefully perused. The grievance of the petitioner is with regard to the lack of promotional avenues in after having rendered several years of service. Stop. There is no quarrel with the fact that as on date, there are no service rules and the draft service rules are pending approval before the government. Stop. There is also no quarrel with the fact that till the rules are approved, there is no bar for the department to proceed on the draft service rules and make available the avenues for promotion to employees like the petitioner if they are otherwise entitled. Stop. It is needless to say that government as a model employer is required to provide avenues for service in order to remove stagnation. Stop. These issues require due consideration by the government, keeping in view the provisions of the draft rules, which are stated to be pending approval before the competent authority. Stop. Since the representation has already been filed before the authority is concerned, and no specific order has been granted, passed on the said representation command. This court is of the considered view that the writ petition can be closed with a direction to the competent authority, more particularly respondent number
1 and 2.
number.
1 and 2, my lord.
It can be 1 and 2. Give me one respondent. Respondent number 1.
1.
To consider the claims of the petitioner seeking promotional avenues in his service as what? Accounts officer.
Accounts officer.
Accounts officer under the Patharkandi Zila Pori. Stop. The department will give due consideration to the claims and the aspirations of the petitioner and thereupon pass appropriate orders. Stop. If there are avenues available for promoting the petitioner, then immediate steps be taken to process the case of the petitioner along with other similarly situated candidates for passing appropriate orders. Stop. As discussed above, there is no bar for the department to place reliance on the draft rules if any decision to that effect is taken by the department till the same are approved by the competent authority. The directions contained given above be complied within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands closed in terms of the above. Interim order, if any, stands marked.
Consider taking note of the notification where 24 number accounts officer has been created.
Cannot be, your lordship. That is especially for a DRDA, your lordship.
No.
So,
This
why not?
24
DRDA employees.
No. This 24 post accounts officer to be posted at Jila Porishad, not for DRDS.
The authorities will give due consideration. While considering the case of the petitioner, the authorities will also take note of all relevant government notifications, including the notification
16
dated.
February 2021.
What is that?
16 February.
Can you see the notification, your lordship?
Page number?
Page number 44, my lord.
Where is the original? 16 February. 2020.
16 February, it's 2021, page 44.
24 numbers of.
No, it talks about Zilla Porichods also.
Yes, my lord.
Posted at Zilla Porishad
And DRD.
and DRDA
Under 6.
under 6 schedule.
DRDA
Your
was-
lordship, can you see in the 6 schedule area, the Zilla Porishad does not exist in lordship.
We don't know. It says
Only DRDA only.
whatever
This
it
is only for the DRDA
Yes,
employees. Your
I am
lordship.
claiming under the non-scheduled areas because Jila Parishad
There
in
is no
non-scheduled
first
areas.
post, your lordship, they
will take into consideration the notification dated 16 February 2021, by which 24 numbers of posts of accounts officers were created to be posted at Zilla Porichods and DRDs. If it is 6 schedule, then how can you
No, my
take a
lord.
claim?
The Jila Parishad is for, well, it is mentioned here, my lord, in the list.
Zilla Porichod and DRDs.
But in the chart, it is specifically mentioned the areas, district.
All right.
Much obliged, my lord.
are like.
Complied, not complied.
Lordship here, Lordship pursuant to Lordship's order dated 24/7, Lordship, because the sole respondent was not, Lordship, a committee has been formed, Lordship. Here the matter is regarding payment of honorarium to village health guide minors. Here the issue which was there was that the direction which was given, that post has been unoccupied. So Lordship had directed us to find out as to how the order can be complied with. Lordship, pursuant to Lordship order, I have this instruction where the committee has been formed, Lordship. And the committee consists of the secretary, director of health services and senior finance editor. Lordship, if the petitioner.
What is the direction contained in the, what is the direction?
Lordship, it's in the page 15 of the contempt petition, Lordship. Para 11, Lordship.
Committee has been constituted.
Yes, Lordship, it has been.
When is the matter likely to be considered?
Exact, because the committee was formed 3 months back, Lordship. So the present status, the secretary, Lordship, as per the communication which I'm submitting to your Lordship, either the secretary and the members of the DHS, they will be able to apply, but they have, Lordship, they have not been made a party, so Lordship may grant.
You
us
get it from the
Yes, Lordship,
department.
Lordship may grant me some time, Lordship, because the petitioners are also.
None appears for the petitioner on call. Mr. A. Chaliha, learned counsel for the petitioner, respondent number,
Lordship, there is a sole respondent, Lordship, but he is not.
sole respondent
yes.
submits that in terms of the directions of this court passed in order dated 26/2/2016 in WPC 847 of 2014. A committee comprising of the secretary as the chairperson, secretary to the Government of Assam Health and Family Welfare Department as the chairman, and Director Health Services member secretary, and senior finance advisor and finance officers as members, finance and accounts officer, health department as members have been constituted by notification dated 13th April 2023 to look into the claims for payment of area honorarium to male village health guides for the period of 1/7/1986 to 31/3/2002. Stop. Mr. Soliha submits that he would like to he be permitted 2 weeks further time to obtain his instructions as regards the status of the compliance of the court's order pursuant to the constitution of the country. Matter be taken up after 2 weeks. Prayer made is allowed, matter be taken up after 2 weeks. Yes. No steps have been taken as per office note dated 1/9/2023 on the newly impleted respondent number 2. None appears for the petitioner or for the respondents. Matter be listed after 2 weeks.
In 37, I'm supposed to place the instruction, my lord, but due to some difficulty, I could not take the instruction, my lord. Maybe taken on Thursday, my lord.
Next Thursday, Lord.
Next Thursday,
Yes, Lord, you want 14, Lord.
why Thursday?
Thursday, my
15th,
yes, yes.
MSA Gayon Learned Council appearing for
For the
Respondent.
respondents. Praise for further time. Stop. MS Bhattacharya submits that matter be listed again on matter be listed after a week, enabling the learned CTC to obtain the instructions. Prayer made by the learned, not CGC, you are appearing as a counsel.
As a count, yes.
Appearing for the respondents is not objected to by the learned counsel to the petitioner, and matter be listed on, let it be on 18th,
18, my lord, I had some difficulty, my lord. 19, my lord.
20,
20, yes, ma'am.
20.
Yes, ma'am. Master.
All right.
May I please, Your Lordship? The respondent number 5 already received the notice, my lord. The service is completed. Please send for admission. For
As per office note, as per Lozima order 1/9/2023. Service on respondent number 5 is complete. Matter be listed for admission. Respondents may file their counter affidavit if so advised.
Lordship.
List again after 3 weeks. Learned counsel, Mr. So appears for petitioner, MS Bhattacharya for the respondents.
obliged.
Look, this is an IML filed by the present incumbent who is holding a post of PCCF. My lord, this application is for dispensing of his personal appearance. To his foundation fact is, my lord, this person is contempts a person. My lord, this person is not added as a present person. The applicant is not added as a party respondent, my lord. And that apart, my lord, this the direction of honorable court also has been complied with, my lord.
Where is that order?
Lordship. Court order is, my lord, at page 9, starts at 9, my lord.
No, this is the order for
Personal appearance.
Personal appearance. Where is the order for?
That is, Lordship will find in this contempt petition, my lord.
On page 18, Lordship starting.
18.
Relevant is page 19.
No, no, আমার নহয় নিমিলে না আমার আমার নিমিলে আমার 21
Page 19, Lordship.
And where is the order passed by the department?
my lord, it is annexed with the IA, my lord.
Where is that order?
It starts at, my lord, at page number 11, my lord. আপনারা জয়েস ছিল না আপনি সিলেক্ট ফিল্ম
And then what happens?
And then, my lords, in the course of this proceedings, my lord, this applicant before your lordship, original contemptor has superannuated, my lord. Now this person has joined. So court, my lord, since it's all pending contempt, my lord, court directed the personal appearance, my lord. So also, my lord, we have filed in compliance with the court order, honorable court's order, my lord, we have passed this speaking order, whereby the claim of the petitioner was considered, my lord. And now, my lords, in that premises, my lord, I humbly pray, my lord, this personal appearance of this person may be dispensed with, my lord.
Where is that order? Speaking order.
Speaking order is at page 12, page 11 of my IA, my lord, application.
By that order, it was passed by your predecessor.
No, now it has been passed, my lord.
Huh?
Now it has been passed.
What do you mean now? Page number 11
Yes, my lord.
is an order dated 14th August.
14 August, my lord.
It is passed by,
The present applicant, my lord.
who is the present applicant?
My lord, MK Yadav, my lord.
Okay,
My lord.
okay.
Now may I submit?
Yes.
Lordship. The thing is that this my learned friend is now saying that the island incumbent was the Lordship office bearer and he was not there. So now Lordship, they have filed their affidavit in opposition. Lordship may come to their affidavit in opposition. How Lordship, if he was not in the office, how he can file this affidavit in opposition in the contempt proceeding? And whether Lordship, they have taken this plea in their affidavit in opposition. Because filed Lordship is on June, the date is not here, Lordship, but it was on June 2023. After filing this affidavit, Lordship, the Honorable Court has held that this person has
It was
committed
filed on 16 June.
Lordship.
And when did the gentleman retire?
No, Lordship, this
Superannuated.
person, this petitioner has filed this affidavit. Lordship.
Huh?
This person, the
Okay.
present petitioner has filed this affidavit, Lordship. Now saying that Lordship, he was not in the office, Lordship. Island incumbent was there and Lordship, he was not the party. If he
No,
was
my
not the
lord,
party,
I-
Lordship, how he can Lordship file this affidavit? First thing. Second thing is that Lordship, after considering this affidavit, this Honorable Court filed order that Lordship 26th July, it was held that Lordship, this person has committed contempt and accordingly he was directed to appear Lordship personally. Now this application has been filed Lordship under what provision? Whether this Lordship, it is a contempt appeal or this is a review petition or Lordship such and such. Lordship. Under what
such
provision
and such?
Lordship this petition can be filed? There is a provision Lordship, section 19 is there in contempt of court. Lordship, if there is a contempt of court, he can prefer appeal before the revision law. So how Lordship, his personal appearance can be dispensed with Lordship after directing him to appear personally?
No, my lords, the issue at hand is, my lord, whether
There is
court's
simple
order has been
Lordship.
complied with or not.
Yes.
What purpose bringing a personal person to here, my lord, serves, my lord?
Let him
No,
comply
my-
with the order, Lordship, first.
Lordship, that order has been complied.
How? It is this, by which order they were directed to Lordship pass speaking order? They were directed to Lordship accommodate this petitioner in a gratuity post.
No, my lord.
Lordship may kindly come to page the original
No.
order.
There was no positive mandamus.
Lordship,
It just issue was also to
Lordship,
consider.
Yes.
We have
Lordship may come
considered.
to
my
page
lord,
19, Lordship first. The specific direction is there, Lordship. Page 19, Lordship, in the contempt petition.
19.
Lordship, page 19 of contempt petition, Lordship. The
Yeah.
first order, Lordship. I am reading the order, Lordship.
Yeah.
I'm reading from paragraph number 3, Lordship.
No,
The first
Lordship, that
paragraph-
is submission. What is the operative party code paragraph 6, my lord? No, my lord, this is a waste of time, my lord.
Why?
Lordship will come to 6, my lord.
Submit. First, whether it is a waste of time or Lordship, they are trying to Lordship suppress this fact. Paragraph number 3. Thereafter, the office of respondent number 1 intimated the office of respondent number 3 to consider the appointment of the petitioner to a grade 3 post, subject to observation the existing rules for the purpose of as indicated in the letter dated 23/7/1988, pursuant to which the respondent number 3 wrote to the additional forest officer, respondent number 6, for appointment of to a grade 3 post on compensation ground, as the said proposal has already approved by the state government. The respondent number 3 thereafter wrote to the respondent number 6 on 2/2/1999, informing the state government approval. The respondent number 6 accordingly in turn wrote to the respondent number 5 for appointment of the petitioner on compensation ground against a grade 3 post. As no action was taken, the petitioner approached this court by filing a writ petition number so, which was disposed of by this honorable court dated so, directing the respondent number 6, namely Divisional Forest Officer, Jubilee Division, to consider the case of the petitioner for appointment on compensation ground to any grade 3 post, in any grade 3 post in terms of the relevant government policy. However, the authority, instead of appointing the petitioner to a grade 3 post, appointed him in a grade 4 post, filed letter dated number so. Being aggrieved, the petitioner has been approaching the authorities for his appointment into a grade 3 post. In this regard, the petitioner has submitted several representations, including representations on 18/12/17. However, the authorities have not responded to his plea for appointment to a grade 3 post. Considering the above, this court is of the view that this present petition can be disposed of with a direction to the respondent authorities to consider the request of the petitioner for appointment to a grade 3 post in terms of earlier proposal made by the department as referred above, and also directed by this court in the aforesaid writ petition.
What is the earlier
Yes.
proposal?
There are two directions was there to appoint this petitioner.
Where was the earlier proposal?
Lordship. Lordship may come to page 12.
Yes.
It was issued Lordship under Secretary the Government of Assam. Sir, in inviting a reference to your letter quoted above, I am directed to say that the proposal for appointment on compensation ground in receipt of Sri Ajay Kumar Mojumdar, son of late Arun Kumar Mojumdar, ex-Forester 1, may be considered against grade 3 post, subject to observation of existing rules for the purpose of including maintenance of roster system. So this was the first lordship. Thereafter, lordship, this approach this honorable court, that order is at page 15. The first writ petition. Lordship got it, page 15.
Then in 16, your case has been approved.
In 15, lordship, I was appointed against get 4 post.
Hmm.
So accordingly, lordship, I filed representation lordship to consider, since my approval was against get 3 posts.
At page 16,
Page 15, lordship, the first,
16.
yes. Page 16,
Your sanction has been approved.
yes,
Proposal has been approved.
against lordship get 3 posts.
Hmm.
So lordship, despite there are so many lordship approval by all department lordship, I have been appointed in get 4 posts. Accordingly, lordship, representation submitted to consider
Now,
my case.
now on what, then what happened? Court
Then
directed.
lordship, when lordship, my representation was not considered, I again approached this court lordship by representation number 8683 of 18. When lordship, I have already read the order, page number lordship 19.
Hmm.
So this court also lordship held that since he was lordship approved against get 3 posts, so he may be accommodated against get 3 posts. So lordship, despite there is 2 specific order lordship and all approval lordship by the under secretary also, they have not appointed by lordship.
Now, on what ground has it been rejected?
My lord,
No,
the words used are considered.
Yes.
My lord will see. My lord,
Consideration has to be
No,
effective
no,
consideration.
No, my lord. It's his.
No,
appointment-
consideration, I do not know how the department will interpret,
My
but
lord.
consider means you will not consider and reject.
Yes.
There was no direction for that.
Consider is to consider, my lord. It doesn't.
No, he has to consider for what?
My lords will see.
He
my
has to
lord,
consider to see whether the
whether
person
he
can be
fulfills-
appointed.
Whether he is eligible for appointment.
No,
No.
whether he is capable of being appointed in that
Exactly,
particular.
my lord, whether he is capable or not, whether he fulfills the norms.
That's
if
right.
He fulfills, he comes into it.
That's right.
And
In
that
these
was
ca-
not taken in the writ petition.
Now,
in
in what
this-
context was his
in this
approval,
context, my lord.
in what context was his earlier proposal approved by the government? If he was otherwise not capable.
My lords,
Page number 16 of the contempt petition,
my lords.
His proposal was approved by the government,
my lords.
which is a communication issued by the PCCF.
Yes. It was also, my lord, in written census, it's my lord that to consider. My lord will see. My
Now
lord
kindly come to page 16 and read that order for us.
My lord, can we kindly appreciate one thing? My lord, his appointment was
Let us first read page number 16 of the
consider the
contempt
case, my lord.
Kindly read page number 16 of the contempt petition.
Yes, sir. Annexed B. Annexed B.
Contempt petition.
And also, what has happened, my lord? Our planes don't match because we brought it later. We have brought it later, my lord.
The matters are listed 2 days prior.
Yes.
There are 2 files for a single bench
My lord.
available.
No,
So some efforts are expected from councils if your briefs are not properly
no, as I stated earlier, my lord,
aligned.
as
with
I
the
stated,
court's
my
brief.
lord, this incumbent was not brought in,
We are not asking for your explanation.
my lord.
We are asking you to read the order at page number 16. If you don't have a copy, we can furnish you with the second copy. Kindly read the order of 2nd
I have-
February
I have.
1999. This is a communication from your PCCF
Yes.
to the divisional forest officer.
My lord, it's 99
Yes.
of 99, my lord, but he was appointed in 2015 against a post, which, my lord, he didn't, he didn't, my lord, object to. He has happily accepted the post, my lord.
I have not.
That point is gone because appointment is of 2015.
On what ground are you rejecting his case?
Because, my lord, his application was processed, his post was considered on the basis of his own application. My application given to the department on arising on 1997, my lords.
So 97 application, in 99, there is a sanction for his appointment
My lords.
in grade 3.
So, my lord, being agreed by that, my lord, non-appointment, he comes to this honorable court, my lord, that court, honorable court, my lord, passes an order to consider, my lord. So considering, my lord, that his application was of 1997, wherein he did not fulfill the norms, my lord, it's still rejected, my lord.
Lordship, this is a contempt proceeding, not a writ proceeding, Lordship. That stand would have been taken in the writ proceeding, Lordship. So this is contempt proceedings. The direction is there, Lordship.
Your order must reflect,
Yes.
my lord, your order which you have passed on 14th August, does it refer to the 2nd February 99 communication?
Only because Lordship, after giving personal appearance, Lordship, this speaking order has been passed. Prior to that, Lordship, we have had a affidavit in opposition. Nothing has been brought on record regarding this, all allegations and facts, Lordship.
We are
My
giving
lord,
you,
99
we are
order,
giving you one final opportunity to complete your instructions. We are
Matter
not
is fixed
passing
on
any
13,
orders in your IA.
my lord,
The order for personal appearance remains.
my lords.
We will direct your officer to appear before the court.
My lords. No, my lord, what has happened in this case, my lord, though this letter is being now shown.
Not
Let-
now, Lordship.
My lordship, let me complete, let me
Yes.
come.
Why now?
My lordship, this 99 letter was agitated in that 2002 round of litigation, my lord. Considering all, my lord, he was, my lord,
Has this letter been withdrawn by your office?
that has to, we have to seek instruction, my lord, because what has happened here also, my lord.
Without verification of these records, you have passed an order
No, my lord, everything has been verified.
justifying that you have considered his case
Lordship.
Yes,
in terms of the order passed by the court. And therefore the order has been complied with.
but that,
This is a reflection prima facie
Yes.
of your willful and deliberate disobedience to carry out
No,
the
my
orders of the court.
My lord will see the order which is under my lordship scrutiny. What is my lord is written here, paragraph 6, my lord. If he agreed, my lord, it is open to him again challenge, my lord. If this is not a repetition, this is not the execution code, my lord.
This is a contemplation.
My lord, you have considered.
We are concerned with the execution of the order
My lord,
to be made by the department.
my lord.
And while executing the order, the department will have to refer to the manner in which you have passed the order. Your office order reflects that his appointment for grade 3 has been sanctioned. In the order where you have rejected, there is not a single whisper of that communication. And you are asking for the personal appearance to be dispensed with.
My lords.
Why?
Because, my lord, in my humble submission, my lord, this order of this honorable court has been complied. There may be some lacuna, my lord. But
If there's a
lordship- if
lacuna,
lordship
then
grants
you
me
have to justify that this lacuna is not willful and deliberate.
My lords will kindly grant me one opportunity, my lords.
13 or 13.
No, 13, my lord, will,
Just 13 already
if
fixed.
my lord, if this keeps hanging, my lord, the lordship also grant me one final opportunity, my lords.
Already it was 13 fixed. That is there also. Let them appear first.
No, what purpose will serve, my lord? If he
Everything
comes, my lord.
We don't know what purpose. We'll just pass orders.
My
What
lord,
purpose our order serves, we don't know.
my lord,
Last 4 years it was pending.
We are
also.
exercising jurisdiction under contempt.
my lord. My lord, that was our anxiety. Since, my lord, this person was not in knowledge of this petition. Only when, my lord, we are
He had
involved.
filed an affidavit,
Affidavit,
it's rightly
yes,
pointed out. How has he
Yes.
contended the contempt petition by filing an
Yes.
affidavit? If
Well-
he is not in the knowledge, what are you saying, Mr. Counsel?
Only, my lord, when we are brought in, my lord, we are asked by the
Please
court. to
don't
assist,
make
my lord.
any submissions if you are not properly
Yes,
instructed.
that may be
My
recorded.
lords.
You are appearing in a contempt jurisdiction.
I understand, my lord. I, with due, my lord, respect, my lord, Parliament will grant me final opportunity once.
So that final opportunity is okay, but this order of the court remains not complied with.
No, my lords, probably there may be, I'll admit, my lord, of the record, my lord, there may be some lacuna, as lordship has pointed out, will justify that, my lord.
This is to be listed on 13(9).
13 lodge.
39, my lords. But 39 for only 39, my lords will kindly dispense with me.
No, why?
Yes.
If my lords is, my lord.
We
grants-
will decide on this dispensation
if my-
after he appears in court.
If my lords grants me time, final opportunity. My lord,
All right, on Monday, you come back on Monday, let us see.
yes, my lord. Very well, Monday then.
Monday.
Monday lodge.
Monday, my lord. Then it's Monday, my lord.
11 lodge.
My lords, Monday.
As prayed for by the learned counsel appearing for the respondent, Mr. T. Gugoi, matter stands adjourned till Monday,
Monday, my lords.
enabling him to complete his instructions in respect of the directions of this court regarding compliance of the order.
Obligement.
Mr. J. Polita appears for the petition, list on Monday.
Monday.
Yes,
Last provision, December, was after the page session.
where is the counsel?
Because they are probably outside.
Nam to reflect for the
And Bhattacharya.
No.
Yes,
Lordship, I have not received instruction in this case, Lordship. I may be allowed 1 week further time, Lordship.
who is supposed to give you instructions?
Chief Engineer, Irrigation Department, Lordship. the Secretary Irrigation Department. of 2015.
Ms. M. Bhattacharya submits that instructions have been sought for, but has not been received as on date. She prays for 1 week further time. Accordingly, matter be listed after 1 week. Prayer made by MS Bhattacharya is not objected to by the learned counsel for the petition of Mr. X. By order dated 22/08/2023, the name of the government council, MS M. Bhattacharya, was directed to be reflected in the cause list. However, the same is not found reflected. Accordingly, registry is to ensure the names of all councils, including the government councils, be reflected in the cause list on the next date fixed. Copy of this order be brought to the notice of registrar division. List on after 1 week. In the event the orders.
18th or 19th, Lord.
In the event. In the event the instructions as sought for by the learned government advocate are not found, are not furnished before the court by the next date fixed, court may consider directing personal appearance of the officers concerned on the next date. List again on so and so date. 18. Yes. Yes.
The petitioner hearing participated in a selection process conducted by the Kajirango Autonomous Council for the post of Assistant Revenue Officer. And my lord, when the results were out, he come to know that my lord, there are large scale anomalies. And my lord, the private respondent number 8, 9, and 10 were selected to those 3 posts. Somewhere, my lord, sons and daughters of the members who conducted the interview. And there are other irregularities in the answer to solution. May I take your lordship to para 11 of the petition straight away?
Yes.
May I just read it, my lord? That the petitioner begs to state that after conducting the selection, the respondent authority did not publish the list of selected candidates. Therefore,
Para 10, you have made certain allegations against the respondents 7, 8, 9.
yes,
10.
yes, 8, 9, and 10 are the selected candidates, and 7.
8, 9, 10, and 11.
Yes, and 7 is the my lord member who sons and daughters have been appointed, and you are the member who took the interview.
Okay. Yes. You are referring to para 11.
Yes. Respondent number 7, my lord, was the member secretary of the Bhai conducting committee. And respondent number 10, who secured the second position, is his son, my lord. May I just complete the pair 11 thereafter. That the petitioner begs to state that after conducting the selection, the respondent authority did not publish the list of selected candidates. Therefore, they silently and without publishing the selected had appointed the candidates, that is the respondent number 8, 9, and 10 as ARO, that is my lord, Assistant Revenue Officer. After coming across the improved selection and appointment, it required an application under the IT Information Act in the office of the Kajirango Autonomous Council, seeking some information which are relevant to understand and establish and nullify the illegal selection and appointment conducted by the respondent authority in appointing the respondent number 8, 9, and 10. Accordingly, the respondent number 7 had furnished the information on 6 queries communication data so and so. It is pertinent to mention here in that the petitioner has received annexed 3 and annexed 4 documental reply in the RTI. The petitioner was once again shocked and surprised to see, in comparing the answers he furnished as reply to his RTI application, the answer sheets of all the 3 selected candidates are missing the signature of invigilators and missing. The answer script do not reveal maintenance of any deviation and uniformity, thus creating and establishing doubt. The answer sheet of respondent number 8, and let respondent number 8 secure the first position, does not contain the signature of the individual except in the first page. More so, his name appears as Nilupal L along his particulars, but his in the answer script he has written his name as Nilupal. There is a difference between E and I. It is unacceptable that the candidate writes his name improperly. The answer sheet of respondent number 9 also contains elements of doubt. The signature of the invigilator at the very first page does not match with the subsequent signature. More so, the right symbol put during assessment of answer number 1 and 3 and answer number question number 4 and 2 page and answer to the question of 14 suddenly disappears for the rest of the answer. More so, there is no mark given to the answer to the question number 20, but added in the total. The answer given of response number 10, which is stand of response number 7, is also without uniformly signed by the invigilator. More so, his answers to what has been not to have been assessed by the examiner, but allocation of marks is there. It is pertinent to mention here in that respondent is the cousin brother of the executive member. The respondent number 9 is the executive of MP, and the respondent number 10, respondent number 11 is the son and daughter of respondent number 7, who acted as the member secretary of the Viva board and the committee. It also reveals from the education documents. The respondent number 9 and respondent number 11 wrote their name while answering question number 13, which may also influence the examiner. Mere examination of the discipline and answer sheet, it seems that some of the answers have been added belatedly at a belated stage only to favor the respondent number 8, 9, and 10, along with the other. The honorable court may wish to contain the records of the selection of AR. My lord, we have got certain documents under the ITI, and I'd like to place those documents, my lord, if the lordship permits.
As a part of recording.
ITI and the
Yes.
My lord, I'm sorry to say, my lord. This would be a part of record. We have not got, my lord, all this answer script, whatever he's producing now before the court. So come with an affidavit. What is that? And today he is filing these documents before the court.
It's their answers, you don't
No, whatever may be answers, he will rely on that. Don't rely then.
If you want to rely, you should bring it on record.
Yes, he should bring on
I can file
record.
an additional.
Huh?
Lordship will permit me to file an additional affidavit to bring on record.
That permission will come only when you make a prayer. You've not made a prayer.
Right now, I'm making mine. Since an objection has come, my lord, I would like to bring it on record.
These allegations that these answer scripts and signatures are all not there. Where have you got this information from? RTI?
RTI.
These are available in the records. Who's for the
Department in
Karbi Anglong? What do you say?
Lordship, my senior today he's not well. He's having fever, Lordship. As such, the
If
records.
senior is having fever, okay, but the records must be available somewhere.
Lordship record, we have it, Lordship, but not with us right now.
Hmm. So your records will be necessary, which will reveal if there is
Lordship.
the allegations made by the petitioner. They are prima facie, they appear to be very serious allegations.
Lordship. Otherwise, we have also filed our additional affidavit, Lordship,
Hmm.
where we have stated the facts.
What have you stated?
Additional affidavit which has been filed on 19/8/2019, Lordship,
Hmm.
filed by respondent number 2.
Stating. How are the candidates placed in before the interview boards?
Lordship, kindly come to paragraph 2, Lordship.
Hmm.
Paragraph 2, where we have stated the department basis state that to fill up 3 posts of assistant revenue officer, the selection process was conducted in 2 phases, Lordship. Written test and viva voce test. The written test was held on 31/8/2014 for 100 marks, and the successful candidates were called for the viva voce test. The written examination was conducted under the supervision of the Vice Principal of DIFU Government College, DIFU. Lordship, there were three interview boards, Lordship, which we have stated in our paragraph number 3.
You say the interview board where the respondent 7 was a member, there the private respondents, what? Which private respondent?
8, 9, and 10.
8, 9, and 10 did not appear.
Lordship, where what they have stated that the father of the interview board in paragraph 3, Lordship, you may come to last 4 para.
Yes.
The interview board number 2 was constituted with Shri Doneshwar Inti, Joint Secretary KAC, Shri Rukting Tiso, Joint Secretary KAC, and Shri Bir Singh Inti, Deputy Secretary KAC. The respondent number 7 was the member of the interview board number 2. The petitioner and the respondent number 8 to 11 were not the candidates allotted to interview board number 2, Lordship. And the interview board number 3 was constituted with Shri Harsin Teron, Joint Secretary KAC, Shri so-and-so, Finance and Accounts Officer KAC, and so-and-so, and Account Officer KAC. The respondent number 9 was interviewed by the interview board number 3, Lordship. In paragraph 3, we have clearly mentioned it, Lordship.
Hmm.
And if you come to our para number 4, the marks allotted are also we have written it, Lordship. How the marks were allotted and what is the
Mr.
position
Das
of the
appears for
petitioner.
Private candidate, respondents,
I am for the private respondent actually.
selected
I am for the-
candidates.
So I'm waiting for Louis Abad. I am for the private respondent in this case. My lord, there were 3 boards. Board number 1, board number 2, board number 3. So far as board number 1 is concerned, the allegation which has been leveled, that 7 is the father and the son is respondent number 10. That's board number 1, this respondent 7 was not there. We have specifically mentioned and the records will reveal. Second, in the board number 1, 8, 9, 10 and petitioner was there in board number 1, where respondent 7 was never in board number 1. He was in board number 2. So where is the question of the allegation which is leveled against the son and father? Because the father has to be there in that board. He was not in that board.
The other members must be
Now
knowing.
I am telling.
The other members must be aware that they are the
That's-
children of.
I will show my lord some judgment. Otherwise, we will not be able to appear in any of the exam. What is important that whether he is in the board or not. And my lord, the most interesting, the written test was held by the DIFU Government College. Written test. Viva was only held by these 3 boards. It is not a case where written test was done by them only. The marks, all evaluation was done by them. And the interesting chief executive member is not a party. Raising an allegation against chief executive member is only a chief executive, not by name. And you said other members influenced. If other members influenced, with great respect, you should make these other members a party, my lord. Then they said that the other members are being also influenced. If that be the case, with great respect, I am submitting before lordship that where is that party they have made? They have not made a party. Raising some allegation that it has been influenced other members, you did not make a party other members, my lord.
All right, we'll have to examine the records because
Sure.
there are some allegations with regard to signatures, names, etc.
Now that's we will give a reply to this, my lord. But your lordship is right, record is important to look into it. And my learned friend has submitted some of the marks, so answer script, which was a part of the earlier RTI. He had the
Mr.
RTI.
Patwari. Mr. Patwari,
Hello.
you want to bring them on record?
Yes, I'll like to bring them on record because I have to have a copy on that.
They were holding this answer script because RTI was made earlier. RTI made, that's a statement.
This is done by ITF.
Yes, yes, you made,
Mr.
but
J. Patwari, learned counsel for the petitioner, grants leave of the court to file an additional affidavit to bring certain documents which he submits will have rel- relevance in deciding. Stop. He prays for
2 weeks time.
2 weeks' time. MS S. Kemprai, learned counsel for the appearing on behalf of the standing council. What is that? Karbi Anglong
Yes, Kalyana Autonomous
submits that the standing council is indisposed and therefore unable to appear before the court. Mr. D. Das, learned senior counsel assisted by Mr. M. Monto appears for
8, 9,
respondents 8, 9 and 10. Mr. C.K.S. Borua for SP.
There is also a criminal case going on.
Respondent number? Respondent number 12. Who is for the others? You are appearing for 8, 9?
8, 9, 10.
8, 9, 10. There's one 11 also. Anyone for 11?
11, no one is. There are 3 posts, 11 is kept reserved. All these 3 petitioners, there are 3 posts, all these private respondents, my lord, on the basis of that they are appointed. 11 is only reserved.
Is a service complete on 11?
Service complete reserved. Service complete reserved. 11 or 11 mark. 11 complete reserved.
Did you take dusty steps on 11?
Since I've been newly engaged, I am not aware.
I'm interested on 8, 9, 10 has been selected. No? 11 is reserved. Why, my lord, I just tell your lordship, 8, 9, 10 is working on the basis of the appointment that was issued. 11 was only kept reserved.
No,
I
but
think-
there is an order for taking dusty steps. We don't know whether dusty steps, because either you have to say that 11 is not required to be made a party, we strike it off. Or if 11 is necessary, then you're duty bound to take steps on 11.
The pilot, since my lord, 3 posts were there and all the 3 posts have been filled up by 8, 9 and 10. At this stage, notice upon respond number 11 may not be necessary. But it may start off.
Why I'm saying, my lord, your lordship is right. To the extent it may be required, because they have made some allegation against respondent number 11, because 10 and 11 are the sons and daughter of respondent number 7.
Yeah,
So some allegation has been leveled against
It
11.
is up to them if you want to.
They want to strike off, very well, they can strike
Also,
off.
I'll just verify with the record whether dusty was taken.
Matter will be listed again after 2 weeks. You verify, take steps if you.
Deeply obvious.
Deep level. May I take those?
By this petition, my lord, I have challenged the impugned order of removal of the petitioner.
Removal from what?
Removal from service as constable.
No.
He was working as the constable. What had happened, he was initially appointed as constable in AP Battalion, on 15/9/1998. On 2016, he was transferred to the Tangaghat Battalion camp. During the period of his service in Tangaghat, on 19 to 2017, a phone call was received by him from his native place, and by saying that his mother got operated and now seriously ill. After getting the phone call, on 22/2017, he submitted a leave petition before the concerned authority, but concerned authority did not respond to his leave petition. Again, on 23/2017, he was received another phone call by saying that his mother was seriously ill and none other in his house.
No. First, you went away after the phone call.
Yes,
Then you submitted a leave petition.
leave petition.
Now, during that period where you on leave or you joined back?
No, the leave petition was not responded. He was still there in the camp. But on again 23/2017, another phone call received.
So after receipt of the phone call, he
went out on 24 to his house.
He went out after the
Yes.
first call or second call?
But second call.
Second call.
Second call on 24/2/2017. He went out and his mother was operated on 25/2/2017. Then on 28/2/2017, a notice was issued to resume his duty. But as per his statement, on 14/3/2017, he returned back to resume his duty, but he did not allow. And then a departmental proceeding was initiated. On 18/5/2017, the first show cause notice was issued. The first show cause notice is at page 22.
Yeah.
And on the charge of gross negligence of duty and indisciplined conduct, rendering unfit to be retained in service as a constable, disciplinary police force. And he submitted his reply by saying that under compelling situation, he did not come in time to resume his duty. And therefore he tendered his apologies to the authority concerned. But without satisfaction with the reply of the petitioner, the second show cause notice page 24, his reply has submitted. Then my lord, on one WT message has sent to him on 14/7/2017. Asked him to appear before the IO for recording his statement. And accordingly, on 2/8/2017, petitioner appeared before the IO. His statement was recorded. And on that day,
IO or EO?
EO. Inquiry officer. On 2/8/2017, and he took along with him his mother, the only defense witnesses, but his mother statement did not record by the EO.
His mother did not record?
Yes, did not record. And then the inquiry report has been submitted. Inquiry report is at page 30. As many as 4 prosecution witnesses has been examined, but the allegation of the petitioner is that the prosecution witnesses statement has not been recorded in his presence, and therefore he could not cross-examine the prosecution witness.
Where have you stated that?
Well, In his reply, the second Toko's reply, he has stated, my lord.
Where is the
Page
second?
32, my lord.
Where is the reply?
Page 32, my lord. Representation.
Paragraph?
Para, my lord. Lord, para 7. I was not given the chance to cross-examine the prejudice in this quite legal. And also another allegation is that the inquiry officer did not record his statement in presence instead of the one ASI, para 6, my lord. ASI clothing branch, Mr. Sahu had recorded the oral statement of the 4 named PWs. There are 9 also here stated that no opportunity was given. Thereafter, my lord, impugned order has been issued on 8/9/2017. Page 37.
Where is the inquiry report?
My lord,
Where is the inquiry report?
inquiry report, my lord, is at page 30.
Yes. Mr. Sharma,
And
Agusami.
another basic ground, my lord, of the petitioner is that he has not given the opportunity to take assistance of a government
You did
servant.
not ask for. Did you ask for?
My lord, I have a judgment, my lord, since he is a lower rank officer, my lord. So in that case, my lord, clearly stated in that judgment, my lord, the concerned authority should have
Any
given
presenting officer and
not presenting officer, my lord, the assisting.
no, any presenting officer appointed?
But as they have stated, my lord, the presenting officer has been appointed.
Where?
My lord, in the page 26, my lord. On page 26, the inquiry officer has been appointed, my lord. Not the presenting officer.
Yes, Mr. Goswami. There are judgments.
Yes.
Do you have that?
Yes, my lord. Para 4, my lord, specifically. para 4, 6, 7, and 9, my lord. Para 4, further, it is also ascertained that no defense assistant was appointed to represent the petitioner. There is nothing to show that the inquiry officer informed the petitioner about his right to appoint a defense assistant to defend his case. There is nothing to show that under any provision of the relevant rules, the delinquent was prohibited from engaging a defense assistance of his choice. There is no reason as to why the said right should not be supplemented in the relevant rules in the interest of justice. The petitioner was only asked whether he wanted to be heard personally or to engage any defense counsel. The above said question cannot be considered as giving information to the petitioner about his entitlement to appoint a defense assistant to defend his case. None of the witnesses produced on behalf of the department for substantiating the changes was cross-examined by or on behalf of the petitioner. There cannot be any doubt that the petitioner was prejudiced in making his defense. Although Rule 16, Part 3 of the Assam Police Manual is silent about the appointment of a defense assistant, in the facts and circumstances, fairness demand that petitioner ought to have been allowed to defend by a defense assistant in the proceeding before the inquiry officer. The petitioner was only a rifleman at the relevant time, and he, being in the lower rank of Manipur Rifles, one cannot reasonably think that he must be knowing about the relevant rules of the departmental inquiry and also about the proper steps required to be taken for his defense. Apparently not knowing the effect or consequences of the statements of witnesses produced on behalf of the department when they were not subjected to cross-examination, the petitioner did not cross-examine any of the witnesses. And para 6, the object underlying the rule of natural justice is to be prevent miscarriage of justice and secure fair play in action. The fact that the statements of the witnesses were not cross-examined by the petitioner clearly shows that despite his denial of the charge against him, he was not knowing the effect of not cross-examining the said witnesses. Though in the counter affidavit of the respondent number 2-3, it is said that one defense witness, namely so-and-so, was examined as a defense witness as prayed by the petitioner. The said statement is not found in the file. In my opinion, the petitioner was immensely prejudiced in his defense as a result of not appointing a defense assistant for his defense. The inquiry is vitiated for non-affording of reasonable opportunity of being heard and thereby for non-following of the principle of natural justice. As observed in the so-and-so, all that the courts have to see is whether there was non-observance of any of the principle of natural justice in a given case and whether the same has resulted in defeating the course of justice, and that what principle of natural justice should be applied in a given case depends on the facts and circumstances of the case. In my considered view, in facts and circumstances of the case, the petitioner was immensely prejudiced in his defense due to failure to provide the sufficient opportunity for engaging a defense assistant. And paragraph 9, in the present case also, the findings of the state departmental inquiry were made on the basis of the statement of witnesses who were never cross-examined, nor reasonably opportunity was provided to the petitioner for appointing a defense assistant for his defense. No presenting officer was appointed by the authority in connection with the inquiry. The proceeding of the said inquiry as against the petitioner was not proceeded fairly in as much as the same was made in violation of the principle of natural justice. The findings made in the inquiry are hereby quashed. At the same time, the impugned orders which were based on the said findings are also hereby set aside and quashed.
Lordship. Lordship, I deferred this judgment, Lordship, because this judgment is not similar to the present case. I will come to that point. Lordship. First of all, page 23 is the statement of allegation against the delinquent, Lordship, against the petitioner, Lordship. Page 23. Unauthorized absent, Lordship. That is the allegation against the petitioner, Lordship. Now, Lordship, unauthorized absent without unauthorized absent, Lordship.
First you tell us about the procedure.
Yes, Lordship. Yes.
Now, if supposing there is a mandate to appoint the presenting officer, you have not done so.
The presenting officer, Lordship. Yes, Lordship. We appointed the presenting.
No, where have you stated that?
Yes, Lordship. Now, Lordship, from the record, Lordship, the petitioner stated, Lordship, that he had not given the opportunity that to cross-examine the witnesses, Lordship. Now, Lordship, all the witnesses were cross-examined by the delinquent, Lordship, during the proceeding, Lordship. it is in the record, Lordship. Moreover, Lordship, from the record, it reveals that he admitted his charge, Lordship, during the course of inquiry. When the inquiry officer recorded the statement of the delinquent, Lordship, he admitted, when the inquiry officer asked that, Apuni সেই সময়ত মাৰ অসুখ হোৱাৰ বাবে কাৰো অনুমতি লবলৈ সুবিধা নাপালে, কিন্তু এই সংক্ৰান্তত পিছত কাৰোবাক জনাইছিলে নেকি? জনোৱা নাছিল। Then Lordship, আপুনি বাহিনীৰ মুখ্য কাৰ্যালয়ৰ পৰা আপোনাৰ কৰ্তব্য যোগ কৰাৰ বাবে পঠিওৱা নোটিছসমূহ পাইছিলে নে নাই? তেওঁ কৈছে he stated পাইছিলো। Yes. আপোনাক কৰ্তব্য যোগদান কৰাৰ বাবে 5 দিনৰ সময় দিছিল, কিন্তু আপুনি সময়মতে জয়েন নকৰিলে কিয়? মোৰ ঘৰুৱা অসুবিধা হোৱাৰ বাবে মই সময়মতে কৰ্তব্যত যোগদান কৰিব পৰা নাছিলো। It's admitted, Lordship. And Lordship, in the examination of the witnesses, when the inquiry officer gave the opportunity that for cross-examination stated Promotional 9, it means he declined to decline the statement. He declined for cross-examination, Lordship. And Lordship, in all the witnesses, he declined. This is on record, Lordship. And Lordship, in the first instance, when Lordship,
Yes.
yellow flag mentions. Now, Lordship, in his reply to the so-called Lordship, it appears that
No, what do you say about the presenting officer?
presenting officer, Lordship, the presenting officer present
And a responsible officer to assist or guide him.
no that in that judgment, which is
Not judgment, I'm talking about the rules. Discipline and appeal rules.
Yes, Lordship.
You follow the discipline and appeal rules.
Yes, Lordship.
So I think there is a rule where it says that delinquent must be provided with an.
No, presenting officer is different, Lordship. Presenting
No,
officer is that
presenting
to
officer is
present
different.
present the prosecution case, Lordship.
Right.
That is for presenting officer.
We are not on presenting officer
Yes,
alone. We are
yes.
saying that some assistance.
No, Lordship, it is not mandatory, Lordship.
I think.
No, it is not mandatory.
You check up the rules, discipline and appeal rules.
Yes, Lordship. But discipline only is that if he suggests the delinquent suggests that he needs one defense.
The whole purpose of making it a part of the rules is that for lower grade officers, they will not have the.
No,
They may not understand the consequence.
In the event of come forward for cross-examination by himself, then only it is necessary.
Rule 9.
If he himself cross-examined the witnesses, how the natural justice was violated?
All right.
He himself cross-examined.
Okay. Anything more?
No, Lord.
That's all. Hard. Reserve. There are better judgments. You have not come up with that. You have left it to the court. We'll do it. All right. Hard. Reserved. রাখি দেবো, রাখি। কালকে রাখি দেবো। এটা হেৰি করো। Yes.
Also a question of promotion, my lord. The petitioner has bad luck, my lord, has been deprived in spite of having support of the authority, my lord. He was initially appointed as a my lord peon, although he was doing the job of his appointment. Your lecture, can you see page 19, my lord? He was appointed 92, but my lord, the regulars on 95. In persons that are already some so and so, the service of Jugan Goy, so and so, stipend employees hereby regularized on so and so under establishment of so and so permanent person. But he joined his service.
What is the name of the petitioner?
Jugan Gohai, my lord. Thereafter, my lord, he was continuing 97, page 21, your lordship, kindly see.
No, what are you,
90.
what is your grievance?
Grievance, my lord, I was appointed in 92.
Hmm.
My
As
service was
what?
regularized
As what?
as grateful employee.
Grateful.
But he is doing the job of computer typing, other LDS of he was
All right.
doing, because since they are.
You were regularly appointed or appointed on ad hoc? Initially,
Was appointed as my lord, not ad hoc.
anyway, you were regularized in
Yes.
2006
As LDA, my lord.
as LDA.
He was initially appointed, my lord,
As grade
no,
4.
no, yes, my lord, grade 4 employee.
Then
my lord.
you were allowed to work
although
as
all
LDA.
LDA, my lord. 97, my lord.
So where is the order of
Public service.
regularization?
Regular, my lord, he was regular as my lord, in 95 in grade 4 post, my lord.
Where is the order?
19, page 19, my lord.
19. Grade 4.
Yes, my lord.
Then,
Although he was discharging the job of grade 3,
okay,
because he is matriculate and he was my lord.
all right, then,
The 21, my lord, that he was been officiate, allowed to officiate as LDA. Although for date of appointment, he was doing the discharging the details and LDA. Thereafter, my lord, here problem came, my lord. Though, my lord, he was supposed to be regularized and but for some reason he could not be. Later on, I'm coming to that point, my lord. Page 25, his regulation was delayed, my lord. That subject to revision without notice and without assigning any reason, without any so and so, it has been upgraded to grade 3. So from 2006 only, he was upgraded. Here is some, my lord. He has given some application. So, my lord, some committee also said, my lord, one, my lord. First, your lordship will come to page 30, my lord. The director has written to the page 30 and Annex 11. Submission of proposal for promotion of instance of district level. With reference to the subject above, you are hereby requested to submit the proposal regarding promotion in respect of Jugan Gohai, junior assistant, under your disposal along with updated final gradation list, vacancy position, and the minutes of district level selection with a meeting of approval at this end at an early date, so as to facilitate issuance of promotion order to the incumbents. That is of my lord 2017, 24 April 2017. Letter written himself by the director to the district agriculture officer, Dibrugarh.
yes.
Thereafter, my lord, also some happenings are going on, but my lord, if I first read the my lord, an inquiry was held, my lord, page 37. That will reflect the entire case. Page 37. Appeal from Jugan Gohai, University and Dibrugarh so and so, 13 November, so advance commission. Claim of the appellant, Jugan Gohai. Working as GADO, Dibrugarh, grade 4 employee since 1992. Regularized as grade 4 in the year 95 in the same establishment. Had been entrusted grade 3 works like.
But your post was upgraded. You were upgraded.
My lord, let me read this inquiry committee report, my lord. All, the entire scenario will come, my lord, from the inquiry report. Had been deprived of a post of junior assistant when 3 posts were lying vacant in 1998. How has been deprived? Because letter goes, PWT message goes from director office to the district, but he was not promoted. In that
No. Promoted to which post? Grade 3. You are seeking promotion to which post?
senior assistant.
now at my lord, senior upper assistant, upper
Senior
division assistant. Other here, the lower division assistant. And if you read the inquiry report, my lord, that will come the picture. Had been entrusted great show like so. He had been after deprived from the junior assistant back in 98. 98, he was supposed to be my lord.
Junior assistant.
Yet, in the 3 post following persons have been appointed, upgraded Farooq Hussain, who had joined on the same date with Jugan, who has grade 4 staff on 15th and 92. Procedural Rahman, direct appointment to junior assistant in 1998. Nivarani Dr. Bora, direct appointment to junior assistant in 1998. He had been led by, so he was contender to the one of the 3 posts. In spite of his efficiency, he had been upgraded as junior assistant on 19/12/2006 only. Had he been provided his dues, he should have been placed at serial as number 2 next to Prabhat Katoki in the gradation list prepared in 2015 by the selection committee headed by DOA, District Agriculture Officer Dibrugarh as the chairman. Date of birth, Jugan Guha is 1st December 1996. Date of birth, Farooq Hussain is 4 February 1973. Both of the above had joined on so and so. Evidences, certificate from, so manner all these are discussed and discussed. Funding and observation, next page 38. Page 38, because all these proceedings were there. Findings and observation. The findings and observation of the undersigned after studying the document and evidences and critically analyzing the matter in an unbiased manner and without any prejudice are as follows. Sri Jugan Guha, with his US SSLC, I don't know what is US. SSLC had joined the department as grade 4 on the same day as that of Farooq Hussain with so and so passed on the same day on 15/10/92. Beyond all reasonable doubt, Sri Jugan Guha had the proficiency and efficiency to execute the jobs entrusted to higher post, and thereby the certificate submitted by him bears sufficient evidence that the erstwhile district agriculture officers entrusted him with such jobs which he performed successfully. Though then were 3 posts vacant for filling up 1998, the intention of the erstwhile authorities may not be termed as malicious, mischievous, and intentional, but leaves a question as to why, the how, and he is left out. The matter needs to be examined. Though he had been produced on 19/12/2006 as junior assistant, the question arises: can he be given a retrospective effect along with his contemporary? Opinion of the undersigned. Articles so and so of the Constitution of India are important article in relation to service matters. Article 14 prohibits discrimination in the actual exercise of the any discriminatory power and strikes at arbitrariness in administrative action and ensures fairness and equality of treatment. In the light of the above and under guidance of service laws and government servants, the opinion of the undersigned is that the claim of so and so needs review to ascertain its correctness and to ensure justice. Justice through delay should never be denied, as denial of justice may be termed an offense of so and so as a public servant. The DO is hereby empowered to arrange for reviewing the matter of preparing a gradation list and making arrangements to promote Sri Jugan Guha to the next higher post when the opportunity arises. This is the report of Joint Director Agriculture, my lord. Responsible officer. Thereafter, actually, what happened, my lord? Page 41, if you see page 40, my lord, type page is at page 40. Kindly approve the following persons are working in this office as grade 4 employee against resultant vacancies. Sri Jugan Guha and Sri Bhupen Gogoi against Sri S. Khan and Sri S. Sengupta promoted to EDA post. So against Sri Bhupen Gogoi and has referred files also. So 99 itself, it is sent by the director. It is sent by the district agriculture officer to the director, my lord. Can be arrange the issue and appointment from your end to the above employee. So his case was recommended in 99 itself. But due to reason not known, he has been left behind. Now, my lord, because his all this politics have happened, my lord, his promotion was delayed to my lord LDA. Now his promotion to the post of UDA also delayed. In the meantime, my lord, the respondent number 5 and 6, both of them are appointed as UDA. So there is no controversy, I think, against the petitioner. And two posts are lying vacant. One post was, my lord, kept vacant by the, my lord, Honorable Court in interim order. And the affidavit also says.
Post of senior assistant.
Yes. Here also another letter shows, my lord. His joint director.
Private respondents are now working
They are-
as senior assistant.
Already they have got, during pendency of this petition, both of them has been appointed. And here another letter page.
Now you consider the case of the petitioner.
Yes,
His date of joining is not 92, Lordship, in the final.
95, okay, 95.
95, Lordship.
90
And
got
Lordship,
regularized.
and Lordship will find in our final gradation list, Lordship, page 34. There
Page
is
35,
another
Lordship, I can
incumbent,
see.
serial number 3, Lordship. There is another person above the petitioner, Lordship.
Hmm.
So as per the roster,
Two posts.
her case will be considered before considering the case of the petitioner. Moreover, Lordship,
There are two posts.
and
Two
she has
posts are-
not
at
challenged, the
present, two
petitioner
posts
has
are-
not challenged the final gradation list, Lordship. And in the provisional gradation
No,
list.
no,
the
if there are
direction-
two posts,
There are
the
two-
that is what she is saying, there are two posts available.
There are two posts at the present vacant.
That Lordship instruction I do not have regarding the
And my
vacancy of
lord,
two posts.
For
Lordship.
the
The last instruction.
sake
that
of
I have received,
argument, my
Lordship,
lord,
is-
all the officers here also page 35, my lord. Here also it is written by my lord, one my lord joint director in 18, my lord, 1st of January 2018.
One post was
Ek
kept
minute,
vacant, Lordship,
just a
because of
minute.
this court's
Ek minute.
Lordship's order.
I have gone through the appeal made by so and so, Dibrugarh, examine along with the supporting evidence so and so, and this, the following issues have been observed. Jogen Gohai has been appointed. guest
Says
post
two
within
posts are
office.
vacant.
Lastly, Minister, my suggestion in this regard is that arrangement be made from your end to form a committee to review this matter in order to provide justice to Sri Gohai. Delaying of justice can be equated with denial of
This
justice.
document has been supplied
It is
by
also
whom?
recently written, 2018.
Who has given this document?
What document?
Lordship,
You have furnished.
Lordship,
In her.
12/5.
Lordship.
12/5/22.
22, Lordship, very old instruction.
But it
Not
says
present
there are two posts lying
Two
vacant.
plus line.
Now instruction I do not have regarding.
As
the
of today,
vacancy.
my lord.
Then why are you giving me this document of 22?
Actually, last instruction that I had.
From her
regarding
affidavit
the
also, it
vacancy.
shows, my lord, that his case is recommended. So already he's going for retirement. So when her instruction will come, the case is pending for last 6 years, my lord. As on today, there are two posts, and my lord, all the officers, higher officers has given in his favor that he should be promoted. And even her in affidavit in opposition also says that, my lord, page, my lord, last page 146. From her opinion opposition, my lord. Yes, yes. Instruction number. কিমান 6 বছৰ হ'ল আৰু মানুহ retire হৈ ঘৰত যাব পিছত। Case will be on, but he will die, my lord.
Lordship may take up my affidavit in opposition, Lordship, page
Yes, my lord.
34.
Page, last page, your lordship, I want to press,
That
because
is
I
the
have not
final
completed
gradation.
my argument, my lord.
Your affidavit means
Opinion
Affidavit of the
respondent 3.
Lordship, respondent
Respondent
number 3,
number three.
Lordship, the director of agriculture.
Respondent 3 affidavit does not contain any page number. You tell me your paragraph number.
Lordship,
Para 10.
15, para 10, Lordship, and annexure 15, Lordship. Second last page. Lordship. That is the final gradation list, Lordship.
We are not on the gradation list. If there are two posts, what is her position in the gradation list?
Fourth, Lordship.
Fourth.
Yes.
Now, what happened to the series
The
person?
first and the second were promoted, the first.
Who are the first and second?
Respondent number 5 and 6.
So they are
Lordship.
promoted.
Yes, yes,
So
Lordship.
now there are one person above her.
Yes, Lordship.
Now, if there are two posts vacant, her
Regarding-
case will be considered.
Yes, Lordship, regarding the vacancy position, I need to seek my instructions, Lordship.
What were you doing You should have added this instruction.
I don't
Yeah,
think
my lord.
Lordship, two posts are vacant.
Huh?
As per my knowledge, Lordship, one post has been kept vacant.
Kept vacant by.
So
three
if one
months
post
at
is
that
kept
time.
vacant,
Then
then
serial
then you see, as per your 2022 instructions, there were two posts.
Mhm.
In the meantime, if one post has been filled up, that means the post must have been filled up by the person above her in the gradation list. So that leaves you with only one post, which is kept vacant by orders on this court.
Yes, Lordship.
So that post will now have to be filled up by her, by the petitioner. If her position is at serial number 4, then there are two posts, 1 and 2 have already been promoted.
Yes, Lordship.
So 3 and 4 are required to be considered now.
Yes,
So what is the difficulty?
yes.
Why you are opposing again?
As per this letter, 2 posts are vacant.
Yes, I.
According to you, at best, 1 post could have been filled up.
Then it would have been serial number 3.
Then it would be serial number 3. So the post kept vacant by the petitioner can now be filled up. Yes, madam.
Yes, madam. Sorry, madam.
Hmm.
Sorry, my lord. Director himself also, my lord. from
No,
our
no, we are trying to pass an order. You tell us what orders you want.
Yes, my lord. I'm totally agree because he's going to be retired, my lord, very soon. This year.
Yes,
itself.
any objections?
By December, he will retire. They have no objection.
We have no idea.
You have no objections.
If he is eligible, Lordship, as per the roster, then he'll be promoted.
What roster now? Now you're bringing
Serial
roster.
number, Lordship. There is.
Huh? You are saying 2 posts vacant. There's nothing, no mention about roster here. You belong to which category?
Himself also, my lord, in-house.
General category.
General, OBC, petitioner OBC, Lordship.
Director himself also, my lord, by letter dated so and so, has submission of proposal for promotion of ministerial staff. Her affidavit of questions she has enclosed. With reference to this above, you are hereby requested to submit the proposal regarding promotion on respect of Sri Jugen Gohain, junior assistant so and so, and other your disposal along with updated first gradation list, vacancy position, and the so and so, committee, and early date facilitate issuance of promotion order to the incumbent. So everybody in his favor, director, joint director, giving report, they are sympathetically, my lord, allowing because he has been deprived earlier. Can we pass the order, man? Because he is also going to be retired 6 years.
When is he retiring?
pending. 31st December, I think. There is no time for my lord adjournment. Sorry, it's a very simple case, my lord. Authority is totally in his favor, my lord, because of some reason he has been deprived.
Where is the gradation list is here?
Yes, my lord.
Where is the gradation list?
Page 34.
Hmm? What is the name of the petitioner?
Jugen Gohain.
Jugen Gohain, my lord.
Jugen Gohain. And respondent 5 and 6?
34. Yes, my lord.
What are your names?
1 and 2.
5 and 6?
5 and 6. Farooq Rahman.
Farooq Hussain.
Yes.
So, and you say the person in serial number 3 is whom? The Mamoni.
Jamuna Sonwal.
Huh?
Jamuna Sonwal.
Oh, she's at number 3.
Yeah.
Where is the gradation list you said? Page number?
Final list 34.
34.
Section 15 of the affidavit filed by the director.
Hmm? 34 of?
Page 34, Lordship, annexure 15
Of
of the affidavit in opposition filed by the
Continue page
Director of
145.
Agriculture, Lordship. Running page
Annexure 34.
145.
okay, it is that this provisional, okay, this is provisional.
Final relation.
I have annexed the final variation, Your Honor.
Since it was delayed in his regulation of this LDA post, that's why he suffered.
So respondent, this person's serial number 1 is R6.
4 minus
Huh?
six.
Farooq Hussain is
6.
R6,
Yes, ma'am. R6.
R5.
I appear on behalf of 5 and 6.
What is the name of 5?
I Farooq Hussain.
That is what we are asking you. R5, then R6.
Faridur Rahman.
Hmm.
কাম কৰি আছে নি নৰ্মেলি কাম কৰি আছে
Number 1.
You have not made the person's serial number 3 a party.
My lord, she has not been, there is no illegality in her, my lord, appointment or other thing. That's why I have not been.
You are
Yeah, my lord,
challenging,
they
you are
bypass.
challenging the promotion of R5 and 6.
5 and 6.
Yes, my lord.
Because he has
That
been
is
earlier
already
one
dismissed.
illegally deprived.
Already honorable court.
Yes. Whatever it is, my lord, long back.
Dismissed.
They
Yes, my lord.
they have been, he was deprived, my lord, earlier. Later on, my lord, as they've been promoted. Earlier illegality has committed, my lord, because his regulation as LDA was delayed.
You are asking for restoration of a seniority to what position?
Now, my lord, present because the last 6 years, here, my lord, now already they have during pendency of the repetition, they have already been promoted. So, my lord, here now, my lord, if he gives the promotion to the UDA, my lord, they are 2 posts vacant. So, my lord, that will be enough for him, my lord. Because during pendency, they have been appointed last year, my lord. No, last year, promotion is. Last year, they have been appointed, my lord.
Are learned counsels for the parties. This writ petition has been filed by the petitioner. Praying for a direction to the respondent authority to promote the petitioner to the post of senior assistant. And to and a further direction to correct the gradation list dated 27/07/2017, restoring the seniority position of the petitioner with retrospective effect from the date of his officiating services as LDA cum typist with effect from 7/6/1997. Stop. The petitioner was initially appointed as a grade 4 employee on 15/10/1992 under the office of the District Agricultural Officer, Dibrugarh. Stop. The petitioner, in the course of his service, was allowed to work as LDA cum typist since 1997 in the same office. Stop. Although he continued to render his services as LDA cum typist, his services were regularized in the year 2006. Stop. The petitioner was aggrieved by the fact that the private respondents number 5 and 6, who were promoted, who were also appointed / promoted to the post of LDA, overlooking the claim of the petitioner, and also without fulfilling the criteria necessary for being considered for the post of LDA, had challenged their promotion / appointment to the post of LDA cum typist by filing WPC number 4810 of 2022. This writ petition came to be, however, subsequently came to be dismissed. Stop. No further appeal was preferred. Well, meanwhile, the petitioner approached the concerned authority, staking his claim for being promoted to the post of LDA, in which he was allowed to work since 7/6/1997. Stop. His case was favorably considered, and the District Agricultural Officer, Dibrugarh, was empowered to what happened then? You were upgraded. You were upgraded to the post of
LDA.
LDA.
Lately, 2006, I was the get in 98.
Then the considering the grievances of the petitioner, the competent authorities passed necessary orders upgrading the petitioner to the post of junior assistant in the year 2000. Which year?
2006.
2006. Stop. The petitioner, however, claimed to be promoted to the post of junior assistant with effect from 1998. You are claiming your promotion from which year?
1998.
1998.
Page 40 as per my note.
Yes.
My name was Sam.
Stop. In view of the fact that the petitioner's claim for promotion was not considered with effect from 1998, his position, according to the petitioner, in the gradation, provisional gradation list which was published was shown at serial number 5. Stop. The respondents number 5 and 6 were shown at serial number 2 and 3. Stop. Being aggrieved, he had filed an application before the competent authority and the competent authority considered his claim for being considered for promotion to the next higher post. And the director, district agricultural officer Dibrugarh was directed to arrange for reviewing the matter for preparing a gradation list and to make arrangements for promotion of the petitioner to the next higher post when the opportunity arises. Stop. Para, it is submitted that during the pendency of the writ petition, the respondents 5 and 6 were promoted to the post of UDA,
Senior.
senior assistant.
Senior division.
Stop. This court, while issuing notice by
Three eight 2018.
Hmm?
2018.
by order dated 13/8/2018, directed the respondent authorities not to fill up the post of senior assistant without leave of the court. Stop. Notwithstanding that, the departments have proceeded to fill up the post of senior assistant by giving promotion to the respondent number 5 and 6. Was it vacated in the meantime?
No, my lord, one post are keeping, one post are keeping vacant as per in terms of this interim order.
You see the interim order? It doesn't talk about one post. Yes, madam. Counsel for the department. The interim order says not to fill up the post,
Fill up the post of senior assistant without the.
leave of the court. Doesn't talk about one post. Be that as it may, the final gradation list has been published in the year 2022, and the name of the petitioner is shown as serial number 4. Stop. Name of the respondents 5 and 6 are shown at serial numbers 1 and 2 respectively. Stop.
May not be filled up without the leave of the court file.
Learned counsel for the petitioner submits that although initially her grievance urged in the present writ petition was to interfere with the promotions granted to the respondents 5 and 6, as they do not meet the requirements prescribed under the rules and they do not have the required educational qualification. Stop. Comma. However, considering the fact that several years have passed by, and in the meantime, notwithstanding the interim order granted by this court, the department proceeded to fill up the posts of senior assistants by giving promotion to the respondents 5 and 6, comma, the learned counsel for the petitioner submits that she would not like to press for the her claim seeking interference with the promotions granted to respondent number 5 and 6. Stop. Learned counsel for the petitioner submits that as per information available, comma, at present there are 2 clear vacant posts of senior assistant yet to be filled up. Stop. If that be the position, then as per the final seniority list, final gradation list of junior assistants, comma, since the name of the petitioner is shown at serial number 4, and as the persons at serial number 1 and 2, namely respondents 5 and 6, have already been promoted, comma, the petitioner will be within the zone of consideration for being promoted to the next higher post of senior assistant, as there are 2 clear vacancies. Stop. The learned counsel for the petitioner submits that the writ petition be allowed, directing the respondents to proceed with the process for promoting the petitioner to the next higher post of senior assistant, and pass necessary orders. Stop. It is submitted that the petitioner will superannuate by 31st December 2023, and therefore there is an urgency that the case of the claims of the petitioner for consideration or for promotion to the next higher post be considered expeditiously by the department. Stop. Para.
It is away 1 month. 1 month.
Para.
At least by 1 month.
Learned government counsels as well as the counsels appearing for the respondents, learned counsel, government counsel appearing for the department submits on the basis of the affidavits filed that and also on the basis of an instruction available with her from the district agricultural officer Dibrugarh, submits that at present, as per the instruction, there are 2 posts lying vacant in the cadre of senior assistant grade 3. Stop. She, however, submits that these instructions are not. These instructions were issued some time back, and she does not have the up-to-date instructions. Stop. She, however, submits that since the petitioner's position is shown at serial number 4 in the final gradation list, there is every likelihood of the petitioner being considered for promotion to the next higher post, as and when the process begins. Stop. This final gradation list is not under challenge.
No.
It is also submitted by the learned counsel appearing for the department that the final gradation list published in the year dated 12/5/2022, whereby the petitioner was shown at serial number 4, is also not put to challenge, and as such the petitioner is accepted
I have challenged by IA, my lord.
by an IA.
Yes, my lord.
But I as an
Five, three.
has not challenged the selection list. Gradation. Mr. So-and-so and so-and-so learned counsels appearing for respondent 5 and 6.
Yeah.
However, submits that
I Lordship, the, he has not challenged your gradation letter.
submits that on the basis of affidavits filed, that the claims made by the petitioner challenging their promotion is unfounded, and their promotions were made as per the rules, and therefore there is no occasion. There is no occasion for this court to interfere with their promotions made to the post of junior assistant.
Actually, I have filed one writ petition, my lord.
Stop.
That has been dismissed. So I didn't file it. The motion dates.
It is, however, submitted by the learned counsels for the private respondents that since vacant posts are shown to be available, the petitioner can always be considered in respect of the vacant posts of senior assistant available. Stop. Para. Yes, you were saying something?
I have challenged their petition, challenged their promotion, my lord, by filing another writ petition.
That we have mentioned. That we
Yes,
have
my
mentioned.
lord, but that was dismissed on the motion stage itself.
Yes, but you did not go and appeal or review.
Petitioner also disappointed.
Where have you challenged the IA in the IA?
IA also there, also gradation list.
No, gradation list is there, but there is no prayer for challenging it.
Present, my lord, he is going to retire, so no complication in the matter again, that will delay.
In the petitioner's paragraph, you write,
Somehow
learned
he
counsel
should
for the
get present.
petitioner has also submitted that an IA, being IA civil number 2958 of 2022, has been filed, praying for due consideration
The gradation.
of the claims of the petitioner to appoint him in the vacant post of senior assistant under the district agricultural office, Dibrugarh. Stop. It is submitted that this IA has been filed as the petitioner has, the petitioner presently does not wish to press with the challenge made against the promotion of private respondents 5 and 6. Para. Learned counsels for the parties have been heard. Pleadings on record have been carefully perused. It is seen that by order dated 13/8, (13/8, 2018), this court, while issuing notice, had directed the respondents not to fill up the post of senior assistant without leave of the court. Stop. This interim order was extended on several dates. Stop. In spite of such clear interim order being passed by this court, it appears that the respondents have proceeded to fill up the post of senior assistant by promoting respondents number 5 and 6. Stop. No application seeking vacation or modification of the interim order passed is found in the records. And the learned counsels for the respondents have also submitted that no such application has been filed. Such action on the part of the respondent without taking leave of the court is not considered appropriate, and the respondents and such actions are and this court does not consider such actions to be appropriate, more particularly when the respondents are represented by the respective councils. False. Paragraph. Stop. Considering the fact that the petitioner has now abandoned her earlier claims, putting to challenge the promotions made to the respondents 5 and 6, and in view of the prayers made in the IA number so and so, this court does not wish to proceed any further in respect of the conduct of the respondent authorities violating the interim orders passed by this court. Stop. After the careful perusal of the pleadings and upon hearing the counsels for the parties, it is seen that the gradation list, final gradation list dated 12/5/2022, the name of the petitioner is reflected at serial number 4, whereas the names of the petition respondents 5 and 6 are reflected at serial numbers 1 and 2 respectively. Stop. There is no dispute. It is submitted by the respective councils for the respondents that the respondents 5 and 6 have in the meantime been promoted to the next higher post of senior assistant. Stop. Consequently, at this stage, the petitioner would be at serial number 2 of the final gradation list reflected in for the post of junior assistant. Stop. That apart, the communication dated 12/5/2022, which was addressed from the office, which was addressed to the Director Agriculture by the Office of District Agricultural Officer, reflects that there are 2 number of vacant posts in the cadre of senior assistant grade 3 lying vacant for the last 3 years. Stop. The communication is dated 12/5/2022. Stop. Although the learned counsel for the department submits that she has no clear instructions on the vacancy position, considering the fact that the interim order dated so and so passed by this court was never vacated, this court directs the respondent authorities to consider the claim of the petitioner for promotion to the next higher post of senior assistant stated to be lying vacant in the office of the district agricultural officer, Dibrugarh. Stop. Dibrugarh, as per the provision of law. Stop. The respondent authority will proceed with the will proceed for taking necessary steps for promotion or initiating the promotion to the next higher grade of senior assistant. Stop. It is expected that the authorities concerned will expeditiously pass appropriate orders in respect of we'll pass appropriate orders and consider the case of the petitioner for promotion to the next higher post of senior assistant under the office of so and so. Stop. This order is passed by the court upon arriving at a finding that the claim for promotion to the post of senior assistant made by the petitioner is not unjustified. Stop. The departmental authorities also have accepted the claim made by the petitioner to the for promotion to the next higher post. Stop. Under such circumstances, the court is unable to understand as to why the delay has as to why the case of the petitioner has not been considered expeditiously, although the departmental authorities have categorically upheld the claim of the petitioner. Stop. In terms of the above findings, this writ petition is allowed, directing the respondent authorities to forthwith consider the case of the petitioner and pass appropriate orders for promotion to the next higher post of senior assistant in the office of so and so. The orders required to be passed by the departmental authorities will be passed expeditiously and not later than the outer limit of 60 days.
30 days, my lord. Nothing much less. 30 days, my. Otherwise,
30
to the vacation comes, my lord, this will not.
60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands allowed and disposed of in terms of the above. IA so and so is disposed of in view of the order passed in WPC number so and so.
Obliged, deeply obliged.
Obliged.
Obliged. Actually, he's trusted